the thing about orals and the oral exams at the Kenya School of Law is that you really have no control over it. You don't have any form of control over it. I can say it's just there. You may land a very good panel. You may land a very bad panel. You may land, you may get an unfriendly panel. But all you can do is, try to do, maybe if you get a bad panel, you can try and do what we call damage control and all. But you have to know that whatever happens during the orals, you have some form of control over it, but you don't have total control over it. So the thing is, it's only 20. Okay, it's only 20 marks. Yes, 20 marks is a lot. But you need to know whatever happens, you still have 60 marks waiting for you in the main exam, and you have the 20 marks in your project work. So don't be discouraged about anything to do with the orals when the results come out, or after you've done your oral exams and maybe you feel some form of inadequacy. Just be encouraged and proceed to read and work hard for the main exams. Yeah, the written examination, which carries 60 marks. So it's totally possible out of 60 marks for you to get a 50. Yeah, for you to get a 55, for you to get a 56, 58. It's totally possible for you to get those marks. Yes. So just go do the orals, give it your best. The best thing you can do, and maybe to reassure yourself, is that you gave it all. You gave it your all. You gave it your best, and that's what you could have. And that's what you could have. You could have got. You couldn't have done any much more than you had done before. So just give it your best. Try and read. You cannot cover everything, obviously. Try and read. But at the same time, know that you have the main exams, the written exams, and you can still pass. I have friends who got 12 in the orals, 10 in the orals. There was one who actually got a 9, and he ended up getting 9 Ps. Another one got an 8. He didn't get the 9 Ps, but he got an 8 Ps, which is totally, actually, an 8 Ps is also up. It's also pass. You're not going to sit for one paper or maybe even remark it. So don't ever be discouraged about the orals and how it turns out for you. And all will be well. Now, on the other thing about orals and how you can better prepare, you cannot cover everything, yes? But, and this applies more so to those who are in week 2, 3 going forward, and maybe, okay, even in week 1, the first 3 days or so. These are the same lecturers who you will appear before. Yeah? And I can give an example. Miss Claire Kigwada will repeat a certain question on this thing, on charges, charges or security. They charge the security in conveyancing. She will repeat the same question for this for different groups who appeared before him. So what you can do, even in the second week and that week, you can at least predict the line of questioning and how they will come, and how those questions will come. You will get conveyancing lecturers will be heavily tilted towards asking conveyancing questions. So for instance, if you meet Ayera is, there are high chances you will get Ayera asking you conveyancing questions. Yeah? So in the morning, at least you can brush up on a few areas before you get into the room and so forth. You will get maybe, for example, okay, there are some lecturers who are not that much predictable. For example, Dr. Omoson. He may ask you questions from any like international law, from something that was in the news yesterday night, and so forth. But the good thing is he's usually very generous. Just don't keep quiet. At least attempt. And if it's an open-ended question, at least try and attempt and give some argument that at least makes sense. You will be able to garner marks. So try and see who your lecturer will be the morning before. Not the morning before. That morning before you enter into that room, try and determine and to know, because you'll know who's going to be in my panel, and then you can at least predict the questions that will come. And then I'm seeing you guys have formed groups. That's a very good idea also. So in the groups, the ones who get out of the panel, so let's say you're the first, second, that person, you can actually send your group mates the questions that you asked, because they tend to ask those questions, to repeat those questions. So they'll repeat and repeat and repeat and repeat. And then now lastly, there are those basic questions which they have to come. And you need to really, really know them, because if you don't know them, lecturers, how can I say, it will have a very, very bad, you'll portray a very bad perception towards the lecturers. Now, for instance, when it comes to civil litigation, there's some basic things that you should at least know. When do you use a plaint? When do you use a petition? When do you use, when do you use a defense? When do you use a memorandum of claim, a statement of claim? How to institute a suit? What's the difference between an application and a pleading? Those basic questions, originating summons. And then there are some questions which particular lecturers love. So if you meet Mrs. Munga, if let's say you find out that you're going to appear maybe before Mrs. Mungare, there are these questions which we've covered before in our previous sessions. For instance, what is the difference between summary judgment and default judgment? Those basic things. Criminal, the same. What is a charge? Yeah, what is a charge sheet? What is the difference between a charge and an information? Are you seeing how those basic questions? What are the types of pleas? Yeah? Other than the types of pleas, what are various defenses in criminal law? So these are some of the questions that lecturers, for example, Dr. Mosa likes asking. They're actually not complicated, basic questions. Yeah, and then what else? Yeah, on criminal, just try go through the course outline where you've reached. Just know something small behind it, and you have time. Okay, today, tomorrow. You still have time. You can at least manage to go through and do some what I usually call it damage control when it comes to orals. Then afterwards, when you're in the room, the key things that you should do is make sure you have confidence, speak audibly, try and speak with authority, don't stammer. So if you appear before Mr. Mwaniki, don't stammer, don't make him feel like you're afraid, or maybe you are you're second guessing yourself, or you're doubting your answer, because the next question will be, are you sure? Are you sure? And some those type of questions but they kind of they can actually destroy your confidence. Yeah. So be confident, speak audibly, try and speak coherently, try and answer the question that the lecturer has asked directly. If you don't understand, you can always pass. If you don't know, if you completely have no idea what that question is talking about, you can pass that question. Okay. And and sorry, somebody called me by mistake and I'm hotspotting using my phone. Sorry for that. So yeah, the most important thing that I'm talking about when it comes to all of this is the confidence that an advocate portrays. So you may have seen, even before a court of law, you have an advocate who's talking with so much authority, and you may find that that person is even quoting wrong provisions of the law, citing wrong sections, talking about, it's you can sema tu ako nje. Yeah. So what you can do is try and polish up on that. You can talk before a group of friends. You can have your friends who will give you some bit of who can ask you some questions, then see how you respond, and then see how you go about it, and you'll be okay. The other thing is praying. If you believe in God, pray, and everything will be well. So you'll have it, and don't be scared. Okay, I can't tell you don't be scared, because personally I was scared up to the last few seconds before I got into that room. So being scared, I won't lie, it's a must. I can tell you, everyone I know and all my friends who I talked to were all scared. All of them were scared before entering into that panel. So what I can say is, you'll be scared, You'll be tensed, but just pull yourself together and get into your room, and you'll be okay. Yeah, just find a way of hiding that, uh, hiding that, hiding the fact that you're scared. So yeah, that's the advice I can give you in those few seconds before we begin. But that's it. Yes, there's somebody who has his, okay, I don't know if it's a he or a she. It's admission number 2020-38. I can't, I can't
Sorry,
see
so
that.
long.
Yeah.
Let me chime in on that. My name is Tyson Mwendwa. I think my status is not known as Mwendwa on that group. I'm rarely active on the team's meetings. But if you may allow me to chime in a few on the orals aspect.
Yeah, please go on. Please go on.
Yeah, the much that I can tell the current students is that I think the best thing for you to have as a tool is the confidence. I think personally for me, I was in the second week of orals, and by the time the first week was coming to an end, by the Friday, the WhatsApp group was actually blowing with questions. This is what I was tested. This is what I was tested. So the pressure becomes octane at some level, which is normal. I'm just telling you in advance because I believe as from Monday, your WhatsApp groups will be blowing up with those kind of messages on this is what I was tested. This is what I was tested on. So for me, what I can tell you at that point is try and have it under control. If it's possible, if you feel like the WhatsApp group is too much for you, you can mute it. Because I think for me, into the second week of my appearance at the panel, I had stopped actually revising because I think there's a previous class of 2019 who came in. We had a Zoom meeting with the guys. Then they just told us, frankly, you guys really don't have control over oral exams. You can read widely, you can read into third term content, but you never know what you'll be asked. So I just decided, for me, what I've read on is enough. So into my final days into my oral exams, I was actually not revising anything. The best thing I did was there's a group that was created by my farm member. We were three guys of us who were just grilling each other on random questions on what maybe we can anticipate in the orals exams. And the good thing is that the two guys, actually what we covered on civil litigation during the orals mock-ups, they were tested on in their panel. One guy actually got a 19 in the orals exams. So what I'm saying in short is that you really don't have control over oral exams, just the way Solonka said. And the best tool for you to have is confidence. Then into your oral appearance, make sure you are well groomed. If it's possible, if it's possible for you, make sure you have a suit. If you don't have a suit, pick a blazer. Hata kama you cannot afford a clean suit, just put on a blazer. For the ladies, the same thing for you. Then there's the aspect of once you get maybe if you are in the morning session, there's usually a room where you guys are swamped into. I think it's somewhere around Mutula Hall. Then there's the whole what's the name of this other hall? You guys are usually placed there. Then after some time, you will be taken into another room upstairs. Then from there, now it's when you are called in the order around which you guys appear in your panels, from 1, I think, to somewhere around 14 or 15. Into the oral room, exam room, it's where the whole shambles come in, because there's a very big distance between the panel and where you are standing. So it depends on how audible you are, because I think for us last year there was the issue of COVID-19, so you had to be on masks all throughout the session. And if your mask is not, or rather if you might not be audible enough, you might end up being in a very sticky situation whereby you are not audible enough, because there's a big distance between the panel and where you are standing. And if for instance, I appeared before Mosa. They gave me the option of either standing or sitting down because there was a bench. Then Dr. Mosa told me, would you prefer sitting or would you prefer standing? So I chose standing because of my confidence levels. So I told him I'll be comfortable standing. And I did my oral testing with that position. Now, the other bit about the appearance in the room is that once you get into that room, make sure you like greet your panel. Maybe if it's in the morning, just greet them a good morning and put up a bright face. If it's in the afternoon, also you can give them a good afternoon, sirs, something of the sort. Then from there, they'll tell you to give your school ID. You'll have to furnish them with the school ID. And I think they'll also ask you to state your names. Now that's where you start gathering your confidence levels. If you're confident enough, you'll speak it out well. Then the next thing they'll ask you, besides you issuing out your school ID, is what is your admission number. So you must also remember your admission number top of your head. Then from there, now it's when they start grilling you. For me, I'll give my practical experience because I was before Omosa, and I think it's Herbert. Herbert does civil litigation, right?
Yeah, but it's civil. But I'm not sure about this current class. Maybe they can.
Yeah. For me, it was my first time
It's civil.
coming across these guys. So I remember Dr. Mosa asked me, have you ever seen these faces before? I just smiled and said, I've never seen them before. Then he asked me, which class are you in? I told him I was in class G. Then he started. He commenced with his names. He told me, I'm Dr. Mosa, is Mr. Halbert. Then he started. Dr. Omosa was the first guy to grill me. He asked me some very funny question, and it was on criminal litigation. I think he asked something to do with sureties. That sureties aspect was a third term topic. I'd never covered it because the last topic we had done was on something to do with conducting a minor's evidence, the child witness process. That was the last topic that we had done. And the further that I can remember was we had done the voir dire. So when he asked me about sureties, I just started talking something. Then I ended up putting in the issue of voir dire. And then he started asking me, okay, now that you brought up the argument of voir dire, tell me what is a voir dire. So in short, what I'm saying is, if it's possible for you guys, you can also try and check the syllabus into third term. What is the scope of the syllabus in third term, and just have something on it. But because for Dr. Mosa, he asked some very funny questions. I really doubt if I ever answered them correctly, but I was confident enough with my answers with him because I just had to think around my arguments and show him that, yeah, I know something along those lines. Then the other guy was Herbert. Herbert was asking me something to do with public and private companies. And he also asked me something to do with the civil litigation on how to institute a representative suit. Now, the funny thing is that my panel, it was a back-to-back session. Omosa asked you one question, you answer it, then Herbert throws in his questions. They were 3-3. So Omosa gives you criminal litigation. After you've responded to it, Herbert comes in with commercial litigation, commercial transactions. So you have to be very smart and on top of your game. You just have to like snap real quick. That is how I came across my orals. Because even when I was coming out of my panel, I was like, wow, it was very tough for me. And the much that I said was that, well, I highly doubt hata kama nitafikisha 10 hapo. Because like for Dr. Mosa's questions, they were really tough. But what gave me confidence is that when I came out of the panel, a friend of mine actually saw me, and then I had to call him and I told him, hey, my brother, I appeared before Dr. Mosa. How is this guy with marks? Then the guy told me, he's very lenient with marks, but that's how he terrorizes our students in orals. That is the only thing that gave me hope. Then apart from that, the much that I can tell you, because for the guys who are in the first and second week, you can imagine you'll be beginning your holidays in maybe, let's say, around 15th of November. The next classes start in January, I think 3rd. So don't lose focus and don't lose sight of it. If possible, keep your brains grinding. Into third term is usually another very tricky session, because third term there's so much to put in, there's little time, and in most cases the syllabus never ends. Like for criminal litigation, for us, we never finished the criminal litigation syllabus. We never did issues to do with the appeals. The issue of habeas corpus was just actually touched on in passing. The issue of extradition was actually touched on in passing also. So if you can possibly try and start gathering into third term topics as soon as you are done with the orals, the better for you. Apart from that one, there's the argument of looking into the past papers. That's the other animal that really helps you into CLE bar exams, because there's usually a constant thread of questions that are usually tested. Like for civil litigation, you'll realize there's usually an application on question 1 or 2, and there's also the issue of drafting a plaint or something around that area, so that into your third term you are able to at least say, I can get something in my CLE exams out of 60, because like we said, oral exams, you really don't have monopoly. Same thing applies to project works. There's a project paper that you guys might end up getting an 18. Another paper will come in where you had hammered a 10 or a 8 or 9. So you cannot even be certain that all your project works will be constantly above 15. It's very unlikely. But if you can pull it through 15 in all project works, that's the better for you. Same thing applies to orals. If you can pull something above 15, that's better for you. When you add the 2, you are having a 30. Come CLE, you are trying to secure a 20 to get to 50. At least if you can get a 30 between project and orals, you don't have a heavy luggage for you to sit in your bar exams. And besides that, at a 20 marks, or rather, the 20 marks that you might be looking for in CLE, was inapotea. I was told that and it sounded funny. Like they usually get lost in that CLE. You are looking for 10 marks and they ended up disappearing. You never know. Just try and do your best between projects and orals. Then CLE exams, let it take care of itself. Then from there, uombe. I think that's the best I can advise you guys. All the best for now. That's the match from me, Solonka.
Thank you so much, man. Thanks so much, Mando. I appreciate that. At least now you've gotten a different perspective of the orals room. So for me, I was asked questions by one lecturer, they finished, then another one asked questions. Now, remember, it was back to back. One lecturer asks a question, another one asks another question, go reverse to the other one, reverse to the other one, and so forth. That's top tier advice. Thanks a lot, Mando, for that. Thanks a lot for that. You'll do well and you'll pass. That's what I know. So maybe we can begin as soon as possible, unless there are questions. Who wants to try? Who wants to be the first person to be asked questions? Mwendo and I can ask you questions as Labins and the rest join in due time. Who wants to volunteer? All right, pick. Who's willing to volunteer? Don't be afraid. The questions are fair. Today is all about boosting confidence. Okay, I can see Pamba Jen. Jen, okay, we can begin with you. So I'll ask you a few questions, then Mwendo will ask you a few questions, then we'll give you the feedback as usual. Okay. And this usually happens, most likely in the first week. The first week questions are usually extremely easy. They're not that bad. So we can begin. Jen, are you ready?
No, but I mean,
that's the spirit. That's the spirit. That's the spirit. Okay, my first question is, what are the types of pleas?
This is under criminal. Oh, thank you for that question. This is under criminal law, I believe. So there are, if I'm not wrong, 5 different types of pleas. The main types of pleas. There's the plea of guilty. There's the plea where an accused person admits guilt. There's a plea of not guilty when an accused person says that they did not do the crime that they're accused of doing. There's the two pleas that come out of the double jeopardy principle. That is the outrefort convict, outrefort acquit, where a person in outrefort convict says that they've been convicted of the similar crime, similar facts, and as a court of similar jurisdiction, outrefort acquit, they've been acquitted of similar crimes, similar facts, and a court of similar jurisdiction. There's the plea of pardon, which is under the constitution given by the president, where a person pleads that they were pardoned by the president of a crime, and they had to have admitted guilt at the time that they were being pardoned. They had to have admitted guilt and probably been convicted so that they can be acquitted. And then there's also the plea of immunity, which comes under the international relations that Kenya has with other countries. Thank you for that question. Yeah, I think those are the type of pleas that I remember at the moment.
Thank you. My next question will be, what's the difference between an appeal and a review? When do you use an appeal and when do you use a review?
So thank you for that question. This is mainly, as I see it, this is actually under both systems of law, the criminal justice system and the civil justice system. And a review is when a court goes through its own judgment. It reviews its own sentence or orders. But an appeal is where a court of a superior court to the court that had the matter, originally, goes through the decisions of that lower court. And mainly, you use an appeal when you are dissatisfied by the lower court, by the subordinate court, or by the superior court's decision. So when you are dissatisfied by a subordinate court's decision, you go to a superior court, you go to the High Court. If you're dissatisfied in the High Court, you go to the Court of Appeal. And then if it's a matter to do with that touching on public interest, then you can move to the Supreme Court. But for a review, you petition the court to review its orders or to review its sentence. So you use a review where you would like a different sentence or a different orders. You're not really, you don't really have much of a problem essentially with the judgment given by the court or the judgment passed by the court. And you use an appeal when you're dissatisfied by the judgment and the decision and the orders of the court. And so you move to a superior court to ask them to review what the subordinate court or the superior court has done. Thank you for that question.
Okay, you're welcome. Thank you. Well answered. The next question will be, what are the types of grants in probate? What list are the many types of grants that you can list for me? It's an open-ended question.
Thank you. Thank you so much for that question. I believe there's an upward of 5 types of grants in Kenya, or under the Kenyan Law of Succession Act, and there's a grant of probate, and a grant of probate is given where the testator or the deceased had written a will. Then there's a grant of letters of administration where grant of probate is given to executors. A grant of letters of administration is given to administrators of an estate where the deceased person did actually not leave a will. A grant of letters of administration with will annexed is given to the administrators of an estate where the testator made a will but did not actually choose executors. So it is given to the executors chosen by the court to administer the will of the testator who did not choose executors. Then there's a limited grant, there's a limited, then there are different types of limited grants. I think I should say that. And they only last for a certain period of time to do specific different things. So like there's a grant ad colligenda bonum, meaning to collect the goods or to collect the property and to preserve it. They're used to collect and preserve the property. There's a grant for special purpose, which is mainly used to kind of remove some property from the property of the testator so that you can maybe use it to pay for school fees or you can use it to pay for hospital bills and things like that. There's a grant ad litem which is used to pursue cases in court. And this is mostly, grant ad litem is mostly taken where there's already a case in court, and so you want to either proceed, you want to proceed with it. And I think I will stop there for now. Yes, thank you so much for that question.
Okay, my next question would be, what's the difference between an amicus curiae and an interested party?
Thank you for that question. Amicus curiae is a Latin term meaning friend of court. So in essence, amicus curiae are people who come to the court to give the court information that they feel is important in making a justiciable and a justiciable decision. So they give pleadings to the court, they give submissions to the court to help them make in essence a better decision. An interested party would be someone who is not necessarily directly affected by the court, but who has an interest in the outcome of the court. Yeah, I think I'll stop there. Thank you for that question.
Thank you for that. Now, that's the last of my questions. Wanda will ask you a few questions, then I'll give you my feedback.
Okay, thank you.
Okay, thanks. To my student, what's your name?
I'm Jane Pamba. Good evening, Wendo. I have a request. Could you please just increase your volume a bit? I'm straining to hear now. I don't know whether I'm the only one.
Okay. Okay. Let me take that again. What's your name?
Oh, thank you. I'm Jane Pamba.
Okay, let me just imagine that you are before Mosa. I'll just ask you a question. Have you seen this panel before you?
No. I have not met any of you before, but I'm glad to meet you today.
Okay, my name is Dr. Mosa. Which unit of your do I take you through?
I think criminal procedure is good for me.
Okay, thank you. On to my first question. What was your last topic in legal writing and drafting?
The last thing we did in legal writing and drafting was drafting of contracts.
Okay. So tell me the difference between legal drafting and legal writing.
Legal drafting, I think the difference between those falls within the meaning of the words themselves, between to draft and to write. So I think to draft is to prepare something, to prepare a version of the document, to prepare a preliminary version of the document, something that you'll be able to correct later. To write, then legal drafting then becomes preparing preliminary legal documents. Legal writing is then actually preparing that document. It's, just like writing is used as a medium of communication, is to prepare that document, and that document, whatever words you put in that document are now what become legal writing, and then that becomes a first draft, which you can change into a second draft, and so on and so forth.
Okay, thank you. Do you know the SOPEC?
Yes, I have been able to interact with it under the professional ethics class.
What is SOPEC in full?
It is a code of standards of professional practice and ethical conduct that was prepared by the Law Society of Kenya in 2016.
Okay, thank you. Could you kindly give me 3 principles under the SOPEC that you might be knowing of?
You're not so this mainly deals with advocates and how they present themselves to the society. And under the SOPEC, an advocate is meant to do the best that they can for the client, as opposed to take any matters that they can unless they have a good reason not to, which relates to the cab rank rule. They're supposed to be honest about their dealings with clients' property, with clients' information. They're supposed to keep clients' information confidential. They're also supposed to be honest with the court, in that they should always remember that they're officers of the court. So they should give whatever information is required to get to a good decision and a justiciable decision at the end of whatever hearing or whatever case it is that they're going through. They should also be transparent and accountable to their clients. So they should always keep in communication with their clients and ensure that they actually put their case before the court and keep looking into it. And yeah, I think those are some of the principles that I can say for the moment. Thank you for that question.
Okay, thank you so much. What was your last topic in criminal litigation?
Our last topic on criminal litigation was about it was about preparation of charges, and it was about charging. It was about preparation of charge sheets. Yes.
Okay. What are the contents of a charge sheet?
A charge sheet contains the name, the particulars of the person, of the accused person that you want to bring before the court. And these are precisely the names, the age, most often nowadays the nationality, the age of the person, from whence they come. Sometimes it also contains the tribe, as far as I have seen some of the charge sheets that I have come through. It contains the OB number for the crime. It contains the date, and different dates, that is, the date when they were brought to court, the date when they were arrested, the date when they took plea. It contains whether or not they were given police bail or they were given any bond or bail in court. It contains the statement of charge. It contains the statement of charge states specifically the crime. So, for example, robbery or murder, contrary to section 203 and 204 of the Penal Code of Kenya. And then the particulars of the charge then become what exactly happened. So you say, so the accused person AB on probably like today, the 30th of October, 2021, in the county, in Tomboya Street in the county of Nairobi, did cause the death of the victim, whose name, CD, by hitting her with a hammer, I suppose, something like that. And then it contains the list of witnesses that will be presented. It contains the particulars of the police station that arrested them and where they're being remanded. It contains alternate charges or alternate different counts and alternate charges. Yeah. Those are what are contained in a charge sheet. Thank you for that question.
Okay, thank you so much. Are you aware of the Constitution of Kenya?
Yes, I am.
When was it enacted?
It was enacted on August 10th, 2010.
Are you familiar with the principles under Article 10?
Yes, I am.
Kindly give me 3 principles under Article 10.
The Constitution is the people of Kenya are meant to live and breathe the Constitution in such a way that it proclaims the national values and principles that we agreed to. And these are, for example, patriotism, unity, human dignity, equality, human rights, non-discrimination, transparency, accountability, good governance, among many. Thank you for that question.
Okay, thank you so much. Have a great evening.
You too,
Thank you. All.
Thank you so much.
Thank you for that. Insightful. Jen, you are seriously prepared for the orals and you're going to perform very well. Yeah, I love your confidence, and it's a great trajectory. You're doing very well, and you answered my questions very well. I would have awarded you very good marks. Now, the only thing that I noticed will be before you answer a question, you begin with the word I think. I think, I think, I think, I think.
Okay.
So maybe you could try and improve on that. More so if you meet other lecturers won't bother, but there are some lecturers who are really particular. I don't know if you're taught by Mr. Moniki and you've done any presentation before him, you will see that he's very particular with the wording. So you'll say, I think, then he'll shout, do you think or do you know? Yeah, or maybe something of the sort. That's Monique and maybe some other lecturers. So you could say something with authority. For instance, if I tell you, okay, the first question I asked you was the types of grants, you gave me the answers very well. You can say, don't say I think, you can say the position or, the types of pleas are, there's a plea of not guilty, there's a plea of guilty, out of 4 acquit, out of 4 convict, and so forth. Yeah, and maybe if you asked a certain question, you can say the position. The position is this. The position as provided for under, for instance, when you talk about review, and the position as provided for under Order 45 of the Civil Procedure Rules is with regards to review. Order 42 with regards to appeals, yes, and so forth. So talk with authority. Talk with you're an advocate. Talk with authority and make sure you're firm. Just stand for it. So the types of pleas, you've answered the question very well. Guilty, not guilty, out of 4 acquit, convict, and so forth. Now the thing about orals is this: the questions may not be as complicated as you think. They may ask you very straightforward questions, extremely straightforward. And they may also bring sorry, muted. Yeah. Okay, thank you. So the questions may be straightforward, and the worst thing about straightforward questions, such as, let's say you're told what's the difference between an appeal and review. The worst thing is, maybe not getting it right, because it's more straightforward. It's better for you to be given something problematic, because you can have open-ended answers. Yeah, that makes sense. But for straightforward questions, try and hit the nail on the head, which you did with me. So when I asked you about the difference between appeal and review, you answered me very well. Now, maybe an area of improvement. Now, for you to, I would have given you maybe an 18. For you not to get maybe an 18 or even a 20, if they want 20 out of 20, we will be giving the positions of the law with regards to it. So you can talk about the appeal. Appeal is provided for under what? Order 42. Review is provided for under what? It's Order 45. You can go cross-check in the Civil Procedure Rules. And then you go on ahead and explain it. And when you're done, you can even, just to show the lecturers that you can even sum it up and now maybe give the main distinctions, the clear distinctions, the outright difference that emanates between an appeal and review. So an appeal lies with the superior court, whereas a review is done by the same court. Now, what are the grounds of an appeal? And what are the grounds for review? For review, the grounds are that there is new evidence that has emanated. There are new facts that have arisen. These facts and this new evidence were not available and could not have been reasonably available at the trial stage. Yes? That way, you leave no doubt to the lecturer that this person knows their stuff. Now, I talked about, I asked you a question to do with the probate, which is very funny since when I entered into my orals panel, I was crossing my fingers that I don't get asked any single probate question because I had it prepared for it. And this actually comes to what I'm going to say. This is the thing, you cannot cover everything, but try to cover as much as you can. Yeah? Personally, there are some units that I can tell you for a fact that I went into that room praying that I'm not asked because I wasn't that well prepared. So don't feel inadequate or feel that you're not ready because you've not covered a certain unit or a certain area. I can assure you that that happens to 99% of everyone who's going to appear before me. Personally, I wasn't well prepared for everything, but I tried to cover as much base as possible. Now, then when I asked you the difference, the different types of grants, You answered it very well. You talked about the grant of probate. So grant of probate applies where? In tested succession. And it's usually given to an executor who applies it to administer the estate of a deceased, the deceased person. Grant of letters of administration also applies. Okay, that not also. Grant of letters of administration applies when it comes to intestate successions. So intestate succession, sorry. And this is where somebody has died without a will, and it's usually given to an administrator. Now, there's usually grant of letters of administration with will annexed. Now, this happens where, okay, there's a will, but the will doesn't provide for, hasn't provided for the executors. And then you went on ahead and gave me the different types of limited grants. That was very good of you. Now, take note. The questions that I've asked, these are some commonly tested questions, commonly repeated questions, so you can try as much as possible to know them. Now, the reason I'm saying this is you may be asked a complex question when it comes to mergers and acquisitions. For instance, out of nowhere, they ask you about a certain company that merged with a certain company, and the lecturer asks you, what was the consideration for that merger? The thing is, if you fail to answer that question, the lecturer may be sympathetic to some extent because they know it's a bit technical and it's a bit complex. But if you ask a question such as, what's the difference? What are the types of limited grants? And then you fail to explain them, that portrays that you're not well prepared, and it's going to portray a bad image on your end. So try as much as possible to grasp these common areas and make sure that in case you're asked, you're going to kill those questions. You're going to answer them very well. In case you're not asked, well and good, it's fine. But there's a real danger when you can't answer some common basic questions. Now, for Jen, you answered this question very well. You got everything correctly. You listed the types of limited grants. You listed ad litem. Ad litem is whereby the deceased wants to sue. The estate of the deceased, so he wants to sue and contemplates maybe suing. So what will the administrators file or executors? They will file what? A grant ad litem so as to provide the authority for them to sue. You mentioned ad colligenda bona defuncti. So ad colligenda, the grant ad colligenda is used to ensure that the estate to gather perishable property and precarious goods. Now, those are the key words. You may not know much about ad colligenda bona defuncti, but just know that it's used when it comes to perishable goods to try and prevent them from spoiling and so forth. And then you mentioned also what are the other types of grants? The others that you mentioned. So try as much as possible to try and cover that base. So you can just write it down in your notepad, and then later on you can go on and look at it and do more research. The last question, I don't know if it's the last question, but the last question that I asked you was the difference between an amicus and interested party. And you gave me a good answer. You gave me a proper answer. Now to move it up a notch, to maybe move it up a notch, and how can I say it? To really show the lecturers that I'm here, my stuff. You can maybe give a case law or I can give case law or this thing, what's it called, or statutory provisions. Now, when you talk about amicus and interested party, I can show you how you can play about these. You may not know facts of this case. You may not know what was even happening in that case. But in all election petitions, all presidential election petitions, you will always see the first thing, the first night before they sit down, what will they be determining, the Supreme Court judges? They will be determining applications from, let's say, the AG applying to become an amicus curiae. There's another party who wants to be enjoined in this presidential petition as an interested party, and so forth. Now, what does that show? That shows that the issue between what an amicus curiae is and what an interested party is was conversed in that case. So even if you have no case law at the top of your mind, you can just play it smart and be like, in 2017. In 2017, you can even bring out the other one now before 2017, 2013. So just go get the dates very well. So you can talk about in 2017, the presidential elections, Raila was the petitioner, and IABC, the Uhuru Kenyatta as respondents. The court determined that an amicus curiae is this and an interested party is this. You can do that. But now, since we're doing this here with you, in case you're asked such a question in the oral exams, the best case that canvassed this issue to death was the case of Trusted Society of Human Rights Alliance versus Mumo Matemo. You can just say Trusted Society of Human Rights versus Mumo Matemo. You can even say Mumo Matemo case. What did the court say with regards to an interested party? Of which then you answered it very well. I'm just now expounding for the colleagues. The difference between an interested party and an amicus curiae is that an interested party, just from the wording itself, has an interest in that case, which you rightly mentioned. Yeah? An interested party has a stake in that proceeding. Yeah? What stake? Meaning this person will be affected by the decision that the court will render. So this interested party will be affected by the decision that the court will render. That's an interested party. An interested party has a stake and has a direct interest in that case. And they will be affected by the decision. An amicus curiae also has an interest, but an amicus's interest is not to any party or any position canvassed by the parties, now respectively. I'm talking about the petitioner and maybe the respondent. An amicus's interest is to the with regards to the fidelity to the law. So this person, as she rightly said, is a friend of the court. And the amicus is only interested in making a decision with regards in the court making a decision of maybe some aspect, professional integrity, or maybe something that's public interest. So he's there canvassing no interest of the petitioner or the respondent, but just to ensure that the interest of justice and the public expectation and maybe the professional integrity is maintained. So an amicus has no interest in the case other than their fidelity to the law. And that's, if you give an answer, if you give a lecturer that answer what Jane just said, and then now back it up with, in the case of Trusted Society of Human Rights versus Mumo Matemo, the courts canvass the difference between an amicus and an interested party. And the ratio decidendi was this. Now, these are just some of the tips to ensure that, you wow the lecturers. You just show the lecturer that this person knows the stuff. So yeah, so that's how I will advise maybe your colleagues who are here. That's how you will how I think you can maybe give the wow factor in your orals. And I think that's my feedback. Other than that, you had a straight 18 out of 20. You answered my questions very well. Now Mwandwa can give my colleague Senior Mwandwa too. I'll give you his feedback on the same. But other than that, great job. You're ready.
Thank you.
Karibu sana.
Okay. Jen, I think from my end, you did well. Safe to note some few ones and twos. First, just like Solonka said, the issue of I think. It was very common in your presentation. I think. Maybe if you can work on that one, it can work towards your advantage. Then there's the issue of there's a point where you are making an argument on legal drafting and legal writing. Then at some point you say so it's like you're posing back into the panelists with the argument. And then the other thing was I was very random with the issue of the questions that I was asking you, because you never know which panel you are appearing before. Some will be your lecturers, some might not even be your lecturers. You might not even have come across them before. It's your first time coming across them. So if possible, you can try and do your research and background checks and understand what does this guy teach. For instance, I think Mutoka, that's criminal litigation. If you appear before Mutoka, that's definitely criminal litigation that will be flowing in your panel. Then on that issue of criminal litigation, I think I asked you the issue of the charge sheet. And I also asked the last question that you covered in class, which is also very common. If possible, try and know the last topic you covered in class, all the 9 units. If you've not been attending classes, to the general guys on the call, try and understand where you guys have reached in your various topics across the 9 units. I think I'm asking that one based on my experience with Dr. Mosa. Dr. Mosa asked me about avoidaya, and that's where we had reached in class, the last topic, because he asked me a very straightforward question. What was your last topic in class? Then I told him it was the issue of child witnesses and conducting avoidaya. Then he began posing me. And if you were keen enough, you'll realize that I was using some sort of leading questions. For instance, I asked you what is a SOPEC. Then I asked you to expound on the meaning of a SOPEC in full. Then I went again to ask you the principles under the SOPEC. That is the same application that was used on me by Herbert, but this time he was cross-examining me on commercial transactions and some bit of civil litigation. That's why I decided, let me use the same technique on you and just appreciate maybe what you might come across in your panel. Then on the issue of legal writing and drafting, I felt like you ended up jumbling yourself around the issue of legal drafting and legal writing. Whereas legal drafting is more technical on the issues of drafting the legal instruments, like drafting of a contract, drafting of a court pleadings. Legal writing is the basic, just the language of a lawyer in simple terms. But at some point, you ended up saying it's preparing a preliminary something on legal drafting. Then again, you sandwiched the issue of preparing something preliminary in your explanation of legal writing. To some extent, you ended up confusing your panelists on the difference between the two, which was not very clear. And again, this one can work against you if you end up jinxing your panel. Then there was the issue of Article 10 of the Constitution. This is also another very common question in orals, and it's just a general a question. It's nowhere in the syllabus at KSL. So it's something that you just need to know. The provisions under the Constitution, I think Article 10 is common. There's also Article 2, 258 of the Constitution, and there's also 22 of the Constitution, and also the issue of enforcement of the Bill of Rights. You should know something across those articles of the Constitution. In some, maybe I can just say there are some key components of the Constitution that you just have to have at your fingertips. Article 10 is one of them, which is also very usually commonly cited in even court pleadings. Then there's Article 258 on how you can institute a suit, as read together with Article 22 of the Constitution. Those are very common provisions of the Constitution that someone like Dr. Owino will be happy to grill you upon on that one. I think in some, that is the much that I can say, but I'll stress again the issue of I think and the argument of it's like you are posing a question at your panelists. Then maybe if I can request you can try and work on your speed, on the pace at which you are presenting your arguments. The good thing with orals is that it prepares you on how you'll be facing a judge or a magistrate before a court of law. It's more of oral or advocacy at the bar. Then if you end up speaking your arguments so fast to the extent that your judge or your magistrate is not even able to record what you are saying, she'll not even end up recording your arguments in court. You understand me? So much so that at least try and work on your pace. I feel like at some point you are so fast to the extent that if it was in open court, the magistrate or the judge would just have paused, put down the pen and just stare at you. Akifika hapo, you definitely realize that you are off. Your magistrate or judge is not recording your arguments. So what you're saying is actually just going off guard. So maybe you can try and work on your pace, but in some, you did well. It was a good presentation. Your confidence level, I think, are top notch, which is something that can work in your favor. And I think there are some instances where you are not very sure about your arguments, but at least you tried and maneuvered your way across it. For instance, the issue of LWD, I think it caught you off guard, and how you jumbled your way across it. The difference between legal drafting and legal writing I loved it. It was actually impressive, and that is just the art of oral advocacy, or rather, oral advocacy. Even before your panel, you just have to have something at your fingertips. You don't know what you are expecting, but you just have to have something at the end of the day to give your panel. I think that is the much I can say from my end. Otherwise, you did well. I thank you.
Thank you. Thank you so much.
Thank you very much. Insightful. You'll do great. You did extremely well, Jen. God, very good. So, who else wants to give it a shot? Who wants to give it a shot? Okay, Mary raised her hand up first, then we'll go to Otieno Amondi. Okay, since I began the last session, Mwendo, would you like to take the honors?
Sure, let me proceed.
Okay.
Even though you caught me off guard, but I'll still go on. Okay, who is appearing?
Mary Dishira.
Okay, Mary, kindly unmute.
Hello, can you hear me?
Yes, I can hear you. Let's say you are appearing in the morning. Good morning.
Good morning, Mr. Mwendo.
Okay, what is your name?
My name is Mary Nyendo Gishira.
What's your admission number?
My admission number is 2021-1854.
Okay, I'm going to ask you some few questions.
Okay.
And on to my first question. Have you come across Francis Murwatetu judgment?
Yes.
What does it talk about?
Well, the recent reading I've had on the Murwatetu was a clarification by the Supreme Court on how the particular precedent should be used, in that it only applies to murder cases. And this was brought about by the confusion that was there after an earlier ruling of the court.
Okay. When
Thank
was
you.
that? I think you are referring to the court directions that were issued in July of 2021, but I was asking about the Francis Murwatetu judgment, of which was to come to the court directions, but that's okay. We can proceed. What was your last topic on civil litigation?
Well, the last thing we did on civil litigation was response to pleadings.
Response to pleadings. Could you explain to us the various ways of responding to a pleading?
Okay, thank you for that question. The various ways we have a statement of defense. You can also traverse or deny. Then we have confession and avoidance. Yes. Thank you.
Oh, okay. Do you know the various ways of conversion of a private company to a public company?
The various ways. I only know of a few ways whereby, of course, you go through the registration process. I don't know if that's what you mean.
In general, because I know in class you were taught about conversion of companies from private to public and public to private and private to public.
Yes.
Will you walk us through the mode of a conversion of a public company to a private company?
Okay, thank you. So the mode, you want me to talk about the mode of conversion of a public to a private company?
Yes, please.
Okay, thank you. So a public company, the conversion of the same, I would first start with looking at the three key or rather unique elements of a public company, in that they are able to transfer shares and also advertise the shares to the public, and also the number of individuals, and also the name of the company itself. So essentially, when you're trying to convert a public company to a private company, then the four issues that I've mentioned earlier, then there needs to be some changes. So for example, you need to change the articles, yeah, in that now in this case for a private company, then you will not be able to sell the shares to the public and also transfer the shares. Also, something else is also when it comes to the name. Yeah, you'll find that most public companies the name is ends with PLC, but now for private company, it's LTD, and also something else. It's also to the number of members. You find that for public company, the least number of members is 7, and 2 a maximum, and then for private is 2 to 50. So first you need to have all those in check to make sure that the conversion process flows smoothly.
Okay, thank you so much. You've done partnerships, right?
Not yet.
You've not done partnerships?
Yes.
Okay, I'll give you a practical scenario.
Okay.
There are 20 partners in a company.
Okay.
That's a partnership, huh?
Yes.
Then there's a suit that needs to be instituted against this 20 in favor of these 20 partners. Huh? They want to sue company X. Let's call company X Safaricom. Will all these 20 partners sue Safaricom?
Well, according to the civil procedure rules, for a partnership, they can use the partnership name. So they do not need to sue all of them, the company, but they will use the partnership name, but they can also include their names. And I think that's all I can say on that particular issue. Thank you.
So the 20 of them will go into this suit, such that it will be the first partner as maybe Tyson Mwendwa, first plaintiff, Solonka, second plaintiff, until to the 20th partner versus Safaricom. Is that what you're saying?
No, what I'm saying is we will have the name of the partner, and then we will have the name of the managing partner. Yeah.
Okay.
Yes.
What was your last topic on conveyancing?
Our last topic on conveyancing was on charges.
What do you understand of charges?
Well, what I understand on charges, it is a term used to refer to a document, or rather, charges applies to land transaction, whereby you are using your land, okay, using your land to secure an obligation. Say, for example, maybe payment of some monies or fulfillment of a certain condition.
Okay. That is all you have to say on charges, right?
Well, we also have the different types of charges. We have a formal charge, and then we also have an informal charge. So for a formal charge, it has to be registered. For an informal charge, it doesn't have to be registered. Okay, something else I can add on charges is that when it comes to charges, the priority of course comes in that it has to be registered for it to have the first effect.
Okay, yes. Thank you so much.
And also we have two parties. Of course, we have the chargee. The chargee in this case is the lender, and then the charger in this case is the borrower. And in most instances, you find that the borrower could be the owner of this particular land, or it could be another person. Yeah.
What happens when the charger is in default?
Well, what happens when the charger is in default? The chargee first will have to issue a statutory notice. Then after issuing a statutory notice, then that is where then after that they can exercise their other remedies are in law, and the remedies in law are in section 90, subsection 2 of the Land Act, which include the right, the right to sue. We have the statutory power of sale, we have listing, we have appointment of a receiver, and then we have possession.
Okay, thank you so much. That is all from me. Thank you. I think Solonka, maybe you can take up the mantle.
Thank you. No problem. Thank you very much. Thank you very much. Thank you, Mary. Thank you, Mary. Now, I've heard you talk about charges. What are the different parts of a charge instrument? Of a charge instrument, what does it have?
Okay, thank you, Pareno, for that question. A charge instrument, of course, it has the parties, and then after that, we have the recitals, and then we have the general conditions, we have the special conditions, and then we have the execution and attestation. Yeah, thank you.
Okay. Now, okay, you've mentioned the recitals. What is in the recitals?
Well, in the recitals, we only have we have the description, of course, of the property, and of course we have the description of the parties as well. And then we also have the party. Now, in this case, the party being the borrower, stating their intention to give their land as security, and of course, also restating that they indeed are the owner of that particular property.
Okay. Thank you for that. Now, what is a power of attorney? And after you've defined what a power of attorney is, kindly give me 3 types of powers of attorney and explain those 3 types of and how different one type is different from another.
Okay, thank you for that question. A power of attorney, I would say a power of attorney is a document where we have the principal donating some of his rights or some of his duties to an agent. Okay, then we have 3 types of powers of attorneys. We have a general, we have a specific, and we have an irrevocable power of attorney. So the general power of attorney, it gives a broad berth to the agent in that the activities that the agent can undertake for the principal are quite wide. Say, for example, the principal could state you could take up any legal matters coming up, or maybe financial matters coming up, or even maybe commercial matters coming up. But then when you come to a specific power of attorney, it tends to be specific in that the authority therein is to perform a specific task. Say, for example, we have a land transaction. So that specific power of attorney, or the authority being given there under, is to the agent to only represent the principal on matters relating to land. Thank you.
Okay, thank you for that. Now, moving onward is you are an interested party. Okay, you think you are an interested party. Yeah. How would you approach the court for you to be joined as an interested party?
Well, for an interested party, considering they have a stake at the particular case, then I would have to first seek leave of the court so that I can be joined in the particular suit.
Yes. How? Okay. Now, how you would seek leave of the court?
Okay, I would seek leave of the court using a chamber summons and of course an affidavit, and therein I will enumerate why I would want to be joined in that suit, and state, for example, say if I am not joined in this suit, then my rights would be prejudiced, or the outcome of the judgment is going to affect me in this way or the other.
Okay, now you've said chamber summons. Are you sure?
I am sure.
100% sure.
Well, yes.
Okay, thank you. Now, okay, let me move forward from that. Now, the next question will be in regards to probate. What's the difference between a caveat, a citation, and a renunciation? The difference between a caveat, a citation, and renunciation.
Okay. In regards to that question, I would like to start with a citation. And for citation, you find it's a situation where one of the beneficiaries of the estate moves to court to prompt the administrator, or rather the executor, to act. Okay, and then you find that the court, of course, will issue directions, and the directions in this case will be either asking the executor to obtain letters of probate, or either they can renounce their executorship. Then the other part is on a renunciation. Renunciation, you find it is where the executor has renounced their authority to act as an executor. And then for a caveat, I would say is where you find that one of the beneficiaries in the estate of the deceased applies to court to have them informed in case any action is taken in regards to the estate of the deceased person, be it maybe granting of letters of administration, or maybe issuance of a temporary grant or confirmation of a grant. So it can happen at any stage. So it just depends with what the particular beneficiary is asking the court.
Okay, thank you for that. Thank you for that. Now, my last question will be, what is nolle prosequi?
Nolle prosequi is a Latin term which means do not prosecute, and this is it is in our Kenyan laws. We have the Constitution of Kenya under Article 157(6) of the Constitution, whereby the Director of Public Prosecution can enter a nolle prosequi against a matter, and this is in criminal proceedings, and it normally happens before judgment.
Thank you. That was the last question I asked you. But before Moro gives his feedback, is the thing that I've liked about you is your confidence, and more so, and this is why I actually wanted to say it before even giving you letting other feedback to be given, is I asked you, are you sure? Then you said yes. Then I asked, are you 100% sure? Then you didn't second guess yourself. Okay, you paused a bit, but then, which is actually normal, but then you said yes, I am sure. So yeah, props to that. I was just trying to get on your nerve on that. And this is something that you will actually find. Also, Ayera, Mr. Ayera, usually like, it's actually the best lecturer when it comes to conveyancing. You will answer a question and then Ayera will ask you, are you sure? Are you 100% sure? Are you very sure? So yeah, I think that's it. I'll give you more feedback after my colleague Mondwa gives you his feedback. But you did well. I appreciate that.
Thank you, Solonka.
Let me just start on that argument of ascertaining herself. Even Dr. Mosa will try and pose a similar issue on you and try and pull are you sure? Then if you're not confident enough, you'll end up starting stammering around, but he's really trying to just see whether you are certain of yourself. Because he asked me a similar issue. I think it was the last question before he stepped out, and he was like, are you sure? Then I had to smile at him and told him, yes, I'm sure. And I stressed on it with a smile on top of it. Then he just told me, yeah, I think that's the whole that I have from my end. Yeah, and I left the room. And before I left, I think it was it was almost the Christmas holidays. I just smiled at them and told them, have a lovely Christmas holidays. And they smiled back and said, likewise to you, Mwendo. Yeah, so you just try and be jovial with your panel in there, at least, and try and just scoop your marks without much burden. So for Mary, I think by and large, from my end, you did well. I think your confidence was on top. Then even the manner in which you are structuring your arguments, I think it was just awesome. And the pace at which you were answering your questions was not very fast. It was not very slow. It was just at 50, which is awesome. Then the grasp of content, it was also in order. If I may just note on the issue of conveyancing, you said that the last topic was on charges, and you pinpointed on section 90 of the LSA on the what happens in default of the chargeor. I think if you end up being caught in a scenario whereby you are referring to a specific provision of the law, be very certain that that's the specific provision of the law, because once it's not the specific provision, or maybe you are referring your panel to the wrong provision of the law, it might work against you. Because under section 90, it's where there's a default, the notices that are supposed to be issued. And again, there's usually a notice, or rather there's a provision that is required under, I think, section 96 before you exercise your statutory power of sale, whereby you have to ensure that there was a first evaluation, and there was the issue of consideration under the Valuation Act. I think there's some 45 days under the Valuation Act or something, valuation rules. So if you are going to a specific provision of the law, make sure you are very certain about it. And the other argument that maybe I can just re-emphasize on is the issue of a representative suit. I was asked this question by Herbert, and he used the very same terms that I've used on you, whereby he told me, he just gave me a classic example, a scenario whereby there are 20 partners in this partnership, and they want to sue company X. Will all these 20 guys go into that pleading? Basically, he was trying to test me on a representative suit, and my answer was no. They really don't have to go into the pleadings per se, but what will happen is one of them will act in favor of the 19 others. That is to say that maybe Tyson Mwendwa, as the plaintiff, suing on behalf of myself and 19 others versus the company that you are trying to sue. That was purely on a representative suit. And the argument that I was trying to test you on is whether in a representative suit, you know that the 20 guys are not supposed to go into these pleadings, but it's only one of them who is supposed to go into the pleadings on behalf of the other guys. I'm not sure if you've covered this one in class, but I highly doubt you'll cover it in any case. But it's something that you should be able to know at a personal level under the civil procedure rules. Then there was the argument on a conversion of a public company to private company. I was also asked this question by Herbert, and the argument is usually what are the key ingredients of a private company. There's usually the shareholding thing. There's the maximum number of members that are supposed to be in that private company, and like in a private company, which is usually tied to how many? I think it's 50, or is it private that is tied to 50? Yeah, and the other public company that is has no limitation on the members who are supposed to be in that public company. That is the key thing that I was trying to test you on, whether you understand what are the key ingredients of a public company and the key ingredients of a private company. Then on the aspect of conversion is that you have to tie the arguments of the key ingredients of one and vary them into the ingredients of the other. I hope I'm clear enough on that one. Then I asked you something on civil litigation. You said your last topic was on defense, and I just tried to throw you off guard with asking you the different types of defenses, and you gave me denying, confession, which I highly doubt is applicable, because in civil litigation, the only way the defendant denies the claim of a plaintiff is through filing a statement of defense or a defense. That's it. There's nothing much, no more, no less. It's either a defense or a statement of defense, which is just one and the same thing. The other issue maybe the defendant can file is a counterclaim, where he feels like he should raise new arguments against the plaintiff. Then the last question that I asked you was on Francis Murwatetu. I really needed you to expound on the Francis Murwatetu judgment, but I think you are acquainted with the court directions that came out in July on this Francis Murwatetu. I'm asking on Francis Murwatetu because specifically it was much at play last year during our orals. And I think it was also because of the appointment of judges was this year, right? But last year, Francis Murwatetu was very much at play in our orals, and apparently it also featured in our CLE exams. I think it was criminal litigation or something of the sort. Francis Murwatetu, the jurisprudence in Francis Murwatetu is a common question. You should also try and know the arguments in Francis Murwatetu. And now they've introduced the court directions in Francis Murwatetu, which happened in 2021. I feel like if you guys have to be asked anything on Francis Murwatetu, the likelihood is you'll be tested on the court directions that were issued in 2021, because by and large, they know Francis Murwatetu has been litigated upon, and there's been so much arguments around Francis Murwatetu in the legal balance. So maybe what your tutor will be trying to ask you is, are you aware of the court directions that were issued on this Francis Murwatetu jurisprudence? Maybe you should be in a position to explain the jurisprudence in Francis Murwatetu vis-a-vis the court directions that were issued in 2021. Maybe the guys on this call can also take note of that one too. And yeah, those are the few questions that I asked you. I think you did well in overall. I just wish you all the best. Thank you.
Thank you, Mwendo.
Yeah, thank you for that. So Mary, you did very well on the issue of are you sure? Are you very sure? that was really nice. That was really nice. So you did extremely well. But now again, similar to Zen, we need to add the the wow factor. I believe don't aim for the bare minimum. Aim for the highest marks possible, because it's possible. Okay. So to give the wow factor, because if you answer all the questions correctly, yes, you answer them correctly and you have an idea, lecturers award you 18, 17, place there. But you need to impress and give the wow, I call it the wow factor. And this is where I talk about trying to merge legal provisions with the answer you give. Now, to begin maybe with the question that I asked you, are you sure? Are you very sure? When I asked you that, I was trying to prompt you to talk about order 1 of the civil procedure rules, and specifically order 1 rule what? Order 1 rule 10. Now, order 1 rule 10 is the one that provides for parties being added to a suit. Yeah? Addition of parties, substitution of parties, striking out a party, and so forth. So that's the provision that I wanted you to talk about. Order 1 rule 10. You make an application to court for you to be joined as a what? As an interested party. Then, when I ask you what is the specific application, you can move on a notch higher and say order 1 rule 10 read together with what? Read together with order 1 rule 25 of the civil procedure rules. Order 1 rule 25 of the civil procedure rules provides for what? That applications under that order 10 shall be made in court using what? A chamber summons. So when you give a lecturer such an answer, how would you approach the court? The answer is, the legal position under that is, I will make a formal application in court to be joined as an interested party. The legal provision or the statutory provision for it is order 1 rule 10, which provides for addition of parties at the discretion of the court, and read together with order 1 rule 25 of the civil procedure rules, which provides for the appropriate application to be a chamber summons. Then you can even move forward and even do what? Impress the lecturers further by talking about the case that I just talked about, Mumu Matemu, Trusted Society, Trusted Society of Human Rights Alliance was Mumu Matemu. Now, in that case, you can talk about what an interested party is and what you need to satisfy for you to become joined as an interested party. Other than that, you gave me the right answer. Now, to move it a notch higher, to impress and give it that wow factor, you need to at least merge the law with the answers you're giving. So yes, that's the answer with regards to how interested parties, how to be joined in as an interested party. Now, the next thing I asked, now let me go into the order, the specific order. I asked you the types of power of attorney. You answered it very well. You answered it correctly. Now, when it comes to, for orals purposes, you don't need to know how these things are really drafted and the specific elements. Just having an idea and speaking it out is sufficient. But after the orals are done, we'll go into the specifics. Now I will show you how a general power of attorney looks like, a specific power of attorney looks like, and how an irrevocable power of attorney looks like. So I will do that later on. But for purposes of orals, again, you answered it very well, but you can move forward and give it what? The wow factor. Impressive. You can talk about Section 48 of the Land Registration Act. That is what provides for issues to do with powers of attorney. Now, Section 48 talks about the registrar not accepting any instrument unless there's a power of attorney that has been duly registered and executed in accordance with Section 45 of the Land Registration Act. So Section 48 is a statutory provision for it. The types, now the different specific types, you can find it under legal notice number 278 of what? Of 2017. 278, that's the Land Registration General Regulations. Now, under legal notice number 278, you will notice now they distinguish between all those three types of power of attorney. So the general power of attorney is from LRA 5. The specific power of attorney is from LRA 6. Don't say special, it's specific. So the difference between general power of attorney and specific is simple. The general power of attorney gives you the authority to do everything and anything. Yeah, it's that general. Now, a specific power of attorney, on the other hand, is towards specific matters. So a power of attorney has been executed for you to deal in A, B, C, and D strictly. Yeah? So strictly you're to deal with A, B, C, and D and no more. But for general power of attorney, you can deal with everything and anything. And then the last one is from LRA 7, and that is an irrevocable power of attorney. Now, this is the thing. I don't want to give the answer specifically. So a revocable power of attorney cannot be revoked. But somebody try and tell me. Maybe you can lift your hand later on. You can think about it. You can do research. But before we finish the session today, you can tell me what's that special distinguishing factor that makes an irrevocable power of attorney not to be, meaning it cannot be revoked. What's that specific thing in an irrevocable power of attorney? Maybe later on somebody can give me an answer. But that's the position. Yeah? We can check legal notice number 278 right together with Section 48 of the Civil Procedure, of the Land Registration Act. Now, the other question I asked you was what are the parts of a charge? Now, the parts of a charge, you mentioned it very well. Okay, I can say you played it safe. You gave me a correct answer, but you didn't go directly into the specifics. But if you have the time, you can go check out those different forms. If you have the time, the same time, if you don't, it's still fine. But just know this: what a charge is, what. Okay, what I can say, if you have time, just check it out. If you don't have, okay, just try to at least check it out. So a charge, the charge you'll usually have. You mentioned the recitals. That's true. So, but you can go into the specifics. The charge has a description of who the charger is. No. It doesn't even need you to look at the instrument. It has a description of who the chargee is. So when you talk about a charge is usually used to secure an interest of a financial or somebody who's lending you money. So it has to talk about the principal amount that is being charged. Yeah. What else does a charge have? Now, the words of, okay, the words of this, something they usually call it when it comes to contracts. I'll try and remember. But this is where that clause that states the chargeor hereby charges the chargeor hereby charges to the chargee. That specific wording, yeah. It usually needs to recite all the words of this. I'll remember it and then I'll get back to you. But yeah, that specific clause. And there are so many various other the witnessing clause, there's the execution, there's a verification, and so forth. But there's one important thing that when you're asked a part of a charge, there's one particular bit that lecturers look out for when they ask you such a question. See, use a description of chargee, description of charger, but there's one particular thing when it comes to a charge. Without this, a charge is defective. And this is an acknowledgement of the effect of Section 19 of the Land Act. An acknowledgement of the effect, meaning you have to have a clause that the charger understands the effect of that charge, and if he defaults, the various remedies available under the charge. That is the most important thing. You can go check out under the form. The specific form is Form LRA 53. I hope you know how to get the forms. So under legal notice number 278, down there are various specific forms. So under those forms, that's where you will get that specific clause and how it's worded. An acknowledgement of the effect of Section 19 of the Land Act. Now, the last, okay, I don't know if it's the last question, but you remind me if I didn't ask you if there's any other question that I asked you and I have left it out. That I asked you was with regards to what is null prosequi. Again, you answered it correctly, and I love how you brought in Article 157 of the Constitution. Good. That's a good thing. Now, to move it a notch higher, we can talk about the Criminal Procedure Code, specifically Section 82 of the CPC. Under Section 82 of the Criminal Procedure Code, it provides for the DPP having authority to discontinue prosecutions at any stage before judgment is entered, and the effect is the person is usually discharged. So that's it. Null prosequi is you can bring out Article 157 read together with Section 82 of the Criminal Procedure Code. And other than that, you did fairly well. I think fairly well, sorry. I'm too happy to be specific with my wording. You did extremely well, and you're going to ace your oral exam. So yeah, you're good. I will have awarded you good marks, extremely good marks. 18 out of 20, you've passed my oral exams. So keep it up, Mary.
Thank you, Pareno, and thank you, Mwendwa.
Okay, thank you very much. Thank you very much. Now, I'm seeing who else has. Okay, now Mary, you've asked the question. So, Omondi, somebody has unmuted. Yes?
May I ask a question?
Me?
It's about the partnership issue, because from the characteristics of a partnership, what I understand, most partnerships have the capacity to sue and be sued. So I wasn't understanding why there was a concept of bringing like a class suit or a representative suit. Well, a partnership has that aspect of being sued and not being sued. Could you expand further?
Okay, now I'll give you my answer, then maybe Mwendwa can also chip in if I've left out anything. So you need, okay, what you need to check out in such a question is, yes, partnerships have the ability to be sued, to sue and be sued. But now, what you need to check out is there are different types of partnerships. There are general partnerships, there's limited partnerships, and there's limited liability partnerships. Now, for general partnerships, how it usually happens is you will list all the types of partners. I think general and limited partnerships, you will list all the partners. So let's say there's X, B, C, D, E. Those are the partners. So you will list X, C, B, D, E trading as these GP, general partners. Yes, the Partnerships Act provides for the suing and being sued on its own name. But for general partnerships, you have to check about the aspect of liability. Yeah, there's that aspect of unlimited liability. Okay, and how can I explain? Yeah, that's the long. How can I put it? That's the long story short to it. When you talk about GPs and maybe LPs, limited partnerships, what will happen is you will sue You will sue those partners and then put trading as so and so. Now for LLP, it's a bit different because for LLP, it's usually, if I can remember, for LLPs, you will sue the LLP itself under its own name. But there's that difference between a GP and an LP, whereby in the general partnership, you will have to list the partners and then sue and then trading as is. But for LLPs, you will sue the LLP itself. It's in its own name. So maybe Mwendo can add on it. Maybe I've left out something, but I'll go get the statutory provisions for you. But it's for the Partnerships Act, because I really before the exam I really read this act. For the GPs and LPs, you can check the Partnerships Act 2012. Section 7 can guide you, and also I think 8 talks about unlimited liability. Then I'll go check out the LLP Act, and then I'll get back to you. But then you can also do a simple Google search at Kenya School at kenyalaw.org case search, and then check out. So the LLPs, law firms that maybe have been sued and the LLPs, how are their names put in the case citation and so forth. But for general partnerships, and this I remember because it's a commonly tested question in the written examination, you're given a question, and then in civil procedure they usually test two main things: how you approach the court, how you have named the parties in the court, and what are those things that you're seeking inside. And one of the key things they test is they tell you this is a general partnership, and then they wait to see how you list the parties. So you will have to list the parties trading as these. So for the partnership. And they also need to remember a general partnership actually, for instance, a general partnership, how does it come into existence? Provided you have two or more people working together with the aim of having profits, it will be considered as a GP, as a partnership of some sorts. Yes. Now, by having that in consideration, they are somehow sort of, what can I say? It's not like a company that's incorporated. It's not a company that how can I say it? It's not that formal per se. You can have a general partnership that's not registered. Yes. And having that thing in mind, you will note that when you go when you go and sue, you will have to list all the persons who are named as their partnerships, and then now expound on trading as partnerships and so on. Maybe Mwendo, please expound if I've left out anything on that.
I think your line of argument, submission is okay. Maybe if I could add is that my question was very general, and it was the very same generality that occurred in my panelist, whereby he was asking me what will happen to these 20 partners. Now, if you look at it from the angle of LLPs, you'll realize that an LLP can sue on its own corporate name because it's a legal person. But if you look at it on the other side of the prism, it's only the partners who can sue in their personal capacities. So I approached it from the angle of the partners are suing in their personal capacity. And from the line of the questioning, it's that this guy was testing me purely on a representative suit. Does the student really understand how a representative suit is instituted, on whether or not will the 20 guys go into these pleadings, or it's just one of them who will go into these pleadings on behalf of the others? That was the main elephant in that room, because this guy was really just trying to understand whether I know the argument on a representative suit. And they gave him the issue of it's only one of them who will sue on behalf of the 19 others. I hope that is clear enough. But if you look at it from the angle of an LLP, you'll realize that these 20 partners in that LLP really don't have to come on board, because the LLP in its own name can sue as against the defendant, maybe Safaricom or any other company for that sake. Now, there's someone, I hope that is clear enough, my brother. What was it?
Yes, it's someone.
Yeah. So how you approach it is how you'll answer it. Yeah? And even before your panel, you'll encounter some very broader questioning. So it's you to tinker around your argument and see which way to follow. Even for me, in my questioning, you could see this guy Herbert nodding in his head in affirmation, and I knew that yeah, I'm well in, because at the end of the day, this guy was purely testing me on a representative suit. Then there's someone who asked a question on the group on the issue of a company a resolution. Yeah, I agree. There's the argument of a company cannot sue before the resolution is filed, but safe to note that under Order 4, you really don't have to file the company resolution at the same time as you are filing the plaint itself. The resolution can come in at the tail end before the hearing, maybe after the case conferencing has happened, because I've practically interacted with such a scenario, and I think is PLO in this call? I think he's interacted with that file too, whereby a company was being sued in Kenya, and these guys are saying that there was no board resolution to institute the plaint in favor of the company versus another company. Then our argument was that the board resolution really doesn't have to be filed at the same time with the plaint because if you read Order 4, I think it's Rule 1, you realize that at any time before the hearing is closed, you guys can file your board resolution to institute the suit in favor of the company. So if I can just answer that question from the chat group, it's that yeah, you really need to file a board resolution, but it doesn't have to be filed at the same time as you are instituting your suit. Maybe if you're instituting your suit as a Safaricom, you'll just draft your plaint and the accompanying documents and then file. This other guy will file in a defense, and maybe at some point you'll also raise a preliminary objection that the company is not properly on record because there was supposed to be what do you call it, a board resolution for it to institute the suit. Then you come back and knock them off on the issue of under Order 4, you really don't have to file the board resolution at the same time that you are instituting a plaint. You can file it at any time before judgment is issued. So during even the hearing, you can file in your board resolution. You can just check on Kenya law on authorities on filing of a board resolution by a company. I hope I have answered that issue. I thank you.
Oh, thank you for that. Thank you for that. Thank you for that. Thank you for that. But now, actually, I have a question. Maybe somebody can tell me what's the effect of filing a suit on behalf of a company and you don't have the authority of. Okay, you don't have. There's no board resolutions in place. What's the effect? I don't know if it can be tested. You may find somebody who's interested in testing, but what's that effect of filing a suit without a board resolution? Who wants to give it a shot? Amondi, or Maura.
No.
Hi.
Hi, can you hear me?
Yes, I can hear you.
Yeah, I think if the company that you are suing on behalf of kind of recedes or says that they never, instructed you, you can be forced to take care of the costs.
Yeah, that's what happens. So if you file as an advocate, if you file a suit without the board resolutions, you'll be liable to pay costs for that suit. You'll be liable. There's liability that will be incurred for that suit. But it's an interesting matter. So the question of GPs, LPs, and LLPs. So you also need to check how they're named in the respective pleading. Check out. Most if you're in Harvard's class, you can go. I don't know. Harvard didn't teach me, but you can go check out how those parties are named and so forth. So what will be the difference between a GP, an LP, and an LLP, and so forth? I don't know if I asked all the questions, or if I answered all those questions. I'm seeing Mary's hand is up.
Yes, Moreno, I just have an issue. I was thinking on the issue of companies, could you also raise the issue of locus standi? Because if you don't have the authority, then does
Yeah.
this officer really have the authority to act on behalf of the company?
Yeah, those are the things that are actually raised, that will be raised in court. Because you see, how does a company make its own decisions? Company makes its decisions through passing of
Resolution.
resolutions. So if there are no resolutions that have been placed, there's no authority to institute a suit in the first place. So it's really crucial for you to have a resolution. At what stage you bring that resolution, it's a totally different question. But it's pertinent for an individual to ensure that you have the resolutions before, that at least as an advocate, you know that there are part of due diligence, that there are resolutions that are put in place for you to institute a suit on behalf of that company.
Okay, the reason why I'm asking that question is I'm just wondering if this particular case will continue to its finality if indeed this officer doesn't have authority, they don't have locus standi. It's upon the other party to raise the issue.
Yeah. So you see, in our court system, and I actually understand, I totally get what Kinabwanda say. In our jurisdiction, we are fairly, how is it called? We are fairly, okay, it's adversarial. The judge would go into those unless now you meet those, donors, or maybe this judge, in the commercial division, Justice Mabea. There's another judge who's very particular, who will maybe read and see. Yes, Mativo, yes, Mativo, very particular. Those judges, those who will read and maybe raise those issues and so forth. But it's for you as an advocate to raise what? To raise a PO. Yeah, to raise a PO and say that this so and so and so and so doesn't have locus standi because of this and this, and the matter proceeds. But if you let it slide, high chances are that, okay, at the High Court they may detect it. But for instance, let's say it's the magistrates' courts. I have a problem with the magistrates' courts because they are usually, how can I say, even submissions. They don't go in depth into these things, and that's the problem. So as it's a duty as part of an advocate, talk about competence and due diligence as an advocate under the standards of professional practice and ethical conduct to ensure that you follow up on this and make sure that your client's interests are well represented.
Okay, thank you.
Maybe if I can just chime in on that one, is that it's not upon the company to raise that argument, it's upon the defense to raise that argument. And in most cases, they usually just file a preliminary objection and say that this company is not properly on record because it has not been given authority to institute the suit. And for instance, I'm giving a practical example with my scenario. What happened is the defense raised that argument after it had filed a defense, just the same way you file a defense and then contemporaneously you file a preliminary objection and say that the suit should be struck out because the company is not properly on record. The argument was being tied under Order 4. And when we saw that preliminary objection, we just proceeded and filed in our board resolution. Then when the matter appeared, because it was appearing before Mativo, he said that a board resolution can be filed at any time. It doesn't have to be filed at the same time instantaneously with the plaint. While you're filing a plaint, you file a board resolution. It doesn't work like that. You can file it at any time before the judgment has been issued. So the PO was just knocked out. Then from there, the matter proceeded to finality on its merits. But in large, if you don't file the board resolution, that suit can also be struck out for being frivolous and vexatious. Thank you.
Thank you for that. Thank you for that. Now,
so long.
Hey, oh, Lavins is here. Nice. Okay. He's back. He was watching football.
Hey, well, it's 10:30. I don't know if you guys have gone.
So far we've done like two, but we've covered a lot of questions. Okay, I don't know. Maybe one of our colleagues, one of the students can see how we've gone. But I feel we've done good. We've covered good ground. We were with the Wandra, and yeah. So maybe since you've joined, you could take up and ask questions. Then now maybe I could do it tomorrow. I can follow up with the questions and so forth. Since you joined, so that at least you get to learn from you also.
Right. Thank you. So who will be the volunteer?
So Mary, we just questioned Mary, and Maura was asking a question. I think Amondi was one who raised his hand. Amondi.
Is it Otieno AP or who?
Yes, Otieno Amondi.
I can also see Ndegwang Guku or something. Right. Otieno, how are you?
I'm very fine.
Are you tensed? Are you happy? Are you delighted?
I'm very fine. Yeah, thank you.
Awesome. So, which week are you in for the orals?
In the second week.
Second week.
Yes.
Great. So, I just proceed with my questions. Just 5 questions, so not much. Okay, so could you just give me 3 ways of commencing a suit?
Thank you for that question. So we have a plaint. We also do have originating summons, and we also have a judicial review. So that's how you can approach the court.
Right. You have mentioned plaint.
Yes.
So a plaint should be accompanied by a number of documents. So how many documents should the plaint be accompanied with?
Thank you.
And please name them.
Thank you. So we have verifying affidavit, a list of documents. We have a list of witnesses, and we also do have, we have a list of statements of witnesses. That's it.
All right.
Yeah,
that's okay. That's okay. Could you give me perhaps 6 instances where a notice of motion can be used?
Thank you very much for that question. So Order 51 of the Civil Procedure Rules is what is going to underpin my answers. And we do have instances where the law is silent on what application should be used by the court. So this is where we use a notice of motion. So for instance, if it is a claim that touches on adverse possession, if it is an issue of lifting judgment, if it is an application for summary judgment, we also do have where it's a marital dispute. We also do have instances where one is approaching court for orders for judgment on admission. Then we also use a notice of motion, and we also use application for stay of proceedings. Those are my answers. Thank you.
All right. My next question, just answer if it's true or not true, or true or false. Okay. So all the applications that you've mentioned can be made ex parte. Is it true or false?
It's true. They can be made ex parte.
My follow-up question on the same: one may file a number of perhaps pleadings as means of opposing an application. So which are these pleadings?
Okay, thank you. So we do have a preliminary notice of objection. Okay, notice of objection, and since it could be a preliminary objection, we also do have replying to, you have a statement of grounds of opposition, and we also do have a replying affidavit. So that is how we will respond.
My last 2 questions again, answer if it's true or false. Okay.
Yes.
So all those pleadings that you've mentioned must be served at least 4 days before the hearing date. Is this position true or false?
It is false.
Okay, what's the grace period upon which all those pleadings you've mentioned could be served before the hearing date?
7 days.
Sorry?
I said 7 days.
Right, my last question. Okay. Again, whether it's true or false. So an applicant, served with a replying affidavit or grounds of opposition can, with the leave of the court, file a supplementary affidavit. Is this position true or false?
Yes, it is true.
That's all, Salonka.
Okay, thank you very much.
Thanks a lot, Lavins. Thanks a lot, Lavins. Now, okay, maybe can, because I'm seeing Dego also Dego's hand is up. Morgan, remember you can ask the questions, then I'll follow up and begin with the Dego and so forth.
Okay, I have two questions.
Yes.
On the first one, please give me the opening statement in Desmond Peter's case.
Okay, thank you very much for that question. Your Honor, okay, let me start. May it please this Honorable Court, Your Honor, my name is Epi Amundi, counsel appearing on behalf of the defense. In this case, Desmond Peter is the defendant. I will then, sorry. I'm so tense.
It's
Your
okay.
Honor,
Let me.
Your Honor, this is a case of mistaken identity. The defendant in this particular case, oh my God, I'll pass that.
Okay, thanks. What was the last topic in trial advocacy?
The last topic we had was a discussion on impeachment of witnesses.
How do you impeach your witnesses?
Thank you for that question. So in the process of impeachment, this is where you discredit the statements made by the witness during the direct examination case. And this is where you look at the three key elements of credibility. You also look at the truth of what was being, the statements that were being made by the witness of the opposing side. So you confirm the truth of what was being mentioned, and then you go ahead and confront the statements that were made by the by the witness of the opposing side. So it's those three elements of confirmation, credibility, and confrontation. So you impeach a witness on those grounds by asking them questions that are leading questions so that you can elicit a specific answer from them. And therefore you can discredit them. Thank you.
Okay, thank you. To my last question, what do you understand by conflict of interests?
Okay, thank you very much for that question. So this is where an advocate or a magistrate or even a judge can have other interests apart from their legal duty towards their client or towards the court, and this can cause a conflict between their personal interests and their legal duties or their legal functions. My legal underpinning for this is based on the SOPEC rules. Under paragraph 99, that is where we see the conflict of interest being illustrated, and paragraph 95 of the SOPEC is what gives us the instances where a conflict of interest can arise. Another aspect of conflict of interest is underpinned in the case of James Bress Muthe, and 22 others. And this case had a situation where the advocate was called upon to be a witness for their client, and that brought about a conflict of interest. There's also another notorious case, the Delphis Bank case, which also brought out the same aspect of conflict of interest. We also have a recent case where Justice Chitembwe was deciding a particular case where the dispute was a sale of land, and the land belonged to one of his family members, and he was listening to that case, and the outcome was deemed to be biased because of that conflict of interest that existed between him being a part of the family that was contesting in the same case, and it was against the defendant, and the judgment was entered in favor of the defendant who was part of his family. So that is my understanding of the term conflict of interest. And because one is entitled to a right to fair hearing as per Article 47 of the Constitution of Kenya, and judicial officers, magistrates, judges, advocates were also required to be impartial as per the Bangalore principles, that is for judges, and also the advocates are also required to be very independent. So that is where the issue of conflict of interest arises. And that is the end of my answer. Thank you.
Okay, thank you so much. In your presentation on the conflict of interest,
Yes.
you talked of the Bangalore principles.
Yes.
Will you kindly tell me what you understand by the Bangalore principles and where they are applicable?
Yes.
Is it on the bench,
okay,
or it's at the judges? And you can give me 3 principles under the Bangalore principles, kindly.
Thank you very much. So the Bangalore principles are principles that are universally accepted as principles that govern and guide how judges should conduct themselves. So it's applicable to judges, and they are from the United Nations. And the principles include impartiality, propriety, independence, equality, integrity, and we also have diligence and competence. So these judges are expected to carry out themselves in this by being governed by these particular principles. And these principles are very key, and they have also been used in other jurisdictions to lay out the foundation of the code of ethics and standards for the judges, and also the whole legal fraternity at large, but it's specifically for judges. Thank you.
Okay, thank you so much. I have no more questions for you.
Thank you.
You did very well. You did very well. You tried. Okay, you were a bit anxious, but you tried. You tried, and that's the thing. You can work on your courage always. Don't ever feel inadequate. It's always a learning process, and you learn each day. And this step you've taken, I'm so sure it will go far in helping you prepare for your oral. So you did very well. Now, Vince and Mondoc will give you your comments, then we'll move forward and question and Degwa together with, I think Sumaya is in. Yes, Sumaya is in. Then after they've given you comments, we'll question Degwa Ngoku with Sumaya.
Mwendo, please go first, and then I'll come afterwards. Thank you.
Okay, I think for me, it's the issue of the first question was on an opening statement. It threw you off guard, and you had to even say you'll pass. And the next line of questioning, you are shaky even from your voice. That is common. And even before I proceed, opening statements in trial advocacy for both Desmond Peters and the other guy what's his name? This Alice Mweni or Mwoki. Those are very common. please, if you're not acquainted with the facts in those two cases, Desmond Peters and Mwoki, go and try and rehash on them. They are very common in oral exams. If possible, have your friends grill you on that issue of the opening statements in either case for both the prosecution and the defense. Because I realized that in my next line of questioning, you are shaky, you are not even certain about yourself. Then you ended up gathering confidence when I asked you the issue of conflict of interests. That's where you now came back in full force, and you answered it pretty well. Only maybe I can add that while you were answering the issue of the conflict of interests, you had so much material in you. You threw in the issue of Bangalore principles. And like when I asked the opening statement, on this other end, the content was overboard, which is okay. But maybe what I can just ask you is, or rather what I can request you is, try and gauge your content. Don't go so far, don't go below. Just keep it at par. Because the risk with going overboard is it will open other loopholes for this guy to grill you even harder. And I'll just give you a practical example with me. I answered something to do with the children's and the Voadaya. And the next thing that Dr. Mosa was asking me is, tell me more about Voadaya. And the only advantage is that I read on the Voadaya argument, so I was pretty sure of myself on that argument. The only problem is going overboard, it will just open extra questions for you. Then the other issues are impeaching the witnesses. I think you answered it pretty well. And maybe what I can just rehash is the issue of the opening statement. And this is just a general concern to the entire guys in the call. Just try and be acquainted with the facts in Desmond Peters and the other lady, Faith Mweni, both opening statement and closing statements on either sides of the divide, the prosecution and the defense. I think that's the match from my end. I thank you.
Thank you very much.
Hello, maybe you can go on.
Thank you. Thank you, Mwendwa. Otieno. Okay, so my feedback are as follows. So the first question that I asked you was about the ways of commencing a suit. You mentioned plaint, which is right. Of course, you know, we have applications like notice of motion. JR may a little bit fall within that. And we have OS, you know, we have petition, we have appeal, etc. So I asked you about the documents that actually do, accompany a plaint. You didn't have much, task on that. You got them right. We have a verifying affidavit. We have a list of witnesses. We have witness statements, and we have a list of documents. So now my other question, which I think sort of, it had taken me back by one of your responses, was when is a notice of motion application used? So you mentioned something to do with adverse possession, and that's wrong. That's through OS, okay? And I think that's something that is quite common. I don't know why people confuse, which application is used for adverse possession. So just know this: where you have a PU, okay, your professional undertaking, which is, for you to enforce a PU is through an OS. So for you to perhaps, file a matter on adverse possession, that's an OS. So the instances where notice of application is used are as follows. I think you got two or three. So one, we have orders for judgment on admission, which I think you got that right. There is a summary judgment, there's stay of proceedings, there's lifting of an injunction, variation or discharge of the same. We also have what we call release orders. For example, we have the habeas corpus order, and then we have application, for a matter to be settled out of court on behalf of persons with disability. I think this is one part that is normally not focused on much. I don't know, because we have, almost negligible or little amount of matters, that is filed on that. And then the other question that I asked you, whether it's true or false. And best believe, a panel member will just ask you, give you a statement and ask you to, whether perhaps true or false. So if you don't have that knowledge on your fingertips, it's easy for you to fall into the pitfall, okay? So I asked you in a statement and I said all these applications can be made ex parte. Is it true? Is it false? It is true. Then a follow-up question on the same, we asked you about perhaps how do you oppose, means of opposing an application, which is quite a common question in the oral exams. Common. So yeah, you got that right. We have a notice of appeal, preliminary objection, okay? And we have different types of objection. We have a preliminary objection, we have a trial objection, we have a post-trial objection, okay? But I think SL only limits, you to appeal. Our firm, did this as our project work for the trial advocacy objections, a whole project work on objections. So the locus classicus of preliminary objection. Okay, the Mukisa Biscuits versus West End Distributors Limited, and then as per Sir Charles Newbold was the president with then. Look at that case, try to go through it, and generally just read on objections. The other means of opposing an application is a replying affidavit, and then the other means, which I think you also got right, is the grounds of opposition. So my next follow-up question again, whether this was true or false, I asked you, all these means of opposing an application must be served at least 4 days before the hearing date. You said that was false, which I agree with you, that was false. And my follow-up question on the same, give me the time frame or the grace period upon which all these means of opposing an application, could be served before the hearing date. And you mentioned 7 days, which is strong. It's 3 days, okay? Then the other last question now was on whether true or false again. I asked you in a statement that an applicant, served with a replying affidavit or grounds of opposition can, with the leave of court, file a supplementary affidavit. And your answer was true, and that's true. You got that right. So yeah, that is all for me. So longer back to you.
Thank you so much. Thank you so much. Now, maybe we can have the last session, and Sumaya is in. Sue, are you in? Sumaya.
Okay, I keep on getting muted. Hi, Solanka, how are you?
Oh, hi, how are you? I'm good, I'm good, I'm good.
I hope everyone is well. Ninakaribisha kwa mheshimiwa. But yeah, I hope everyone is well, and the nerves are being contained. So yeah, we can do the last session.
Okay, no problem, no problem. So maybe you can begin and then you can follow up. So that they get an opportunity to learn from you since you're here. I've asked several questions.
Okay,
different
cool.
panelists. So okay.
Who am I questioning?
Actually, sorry, I'm seeing you here, and Alex is also. I didn't even know Alex was in. Alex, are you in? Alex.
I'm in the meeting.
Nice. I didn't even know you were in. Sorry for that. So Sumaya, maybe you can ask, and then Alex will follow up. So that you guys.
Or me and Alex can ask the same.
Yes, Alex and you. Yes.
Yeah. So who's going?
Either two.
No, as in who are we questioning?
Oh, it's Ndegwa
Yeah, it's
Nguku.
me. Okay, can you introduce yourself, Ndegwa?
Okay, thank you. My name is Ndegwa. Currently a student at the Kenya School of Law. My student ID number is 2021-0724. And I'm in class E.
Okay, hi Ndegwa, how are you?
Yeah, fine, thank you. Fine, thank you. And you?
I'm fine, thank you. So this is your oral exams. Why are you doing these exams today?
Yeah, as part of the advocates training program, in order to become an advocate, to be admitted to the role of advocates, all students, after they finish their LLB degree and who wish to be admitted to the bar, have to go through the process of doing an oral exam. So besides doing the oral exam and doing the main bar exam, this is one of the prerequisites for that.
Okay, thank you for that. So which topic would you like to be asked on? What are you comfortable with?
Yes, I'm okay with conveyancing, criminal litigation, and yeah, and commercial transactions. So
Okay, so maybe we can start with criminal. What's the difference between a review and a revision?
okay, thank you for that question. So for review, this occurs where after a judgment is given by a magistrate or a judge, new evidence comes up, which was not previously privy to the judge, which might actually make the judge change the merits of the decision. So when new evidence is brought up, there's a possibility for the accused or for the prosecutor to present that evidence back to the judge to see whether it will make a change to the merits of the decision. So, but that's for review. But for revision, I stand guided on the same. So allow me to pass on that.
Okay, no problem. So moving on swiftly, you said you're comfortable with commercial transactions, right?
Yes, I am.
Okay, can you give me the 5 major steps of a merger transaction?
Okay, thank you for that question. So I'll first start by defining what a merger is, and this is under Section 56 of the Competition Act, which defines a merger to be
Are you sure it's Section 56?
Yes, I believe it's Section 56.
It's not Section 42?
Yeah, sorry, it's Section 42. Sorry, yeah, Section 42 of the Competition Act. Thank you for that. Which defines a merger to be the consolidation of assets or the consolidation of shares of two different companies to become one company, and also includes a takeover. So the 5 steps involve the first thing being due diligence. So this is whether there are pre-contract inquiries between the two companies which want to merge, or where one company wants to acquire another company. The due diligence is done through assessment of financial statements, assessing the company's financial records to see how they're performing. And once that's done, the next step is to do the application to the Competition Authority of Kenya for the purpose of reviewing whether such a transaction would actually be approved. In the process of doing so, the Competition Authority of Kenya looks at whether that specific transaction would prevent or harbor competition in the market for a specific market, the relevant market in this case. So for example, if it's the oil or petroleum sector, in such a scenario, for example, if it's Shell and Total, which is merging, the CAK would not actually approve of that because of the amount of market share they have in the market. So once the CAK does approve of it, the next step is to proceed with the documentation, registering it through, I believe it's through Citizen. So the relevant documents are involved, the procedure of now combining these two companies eventually comes together. So that will be my answer.
Okay. I feel like you haven't satisfactorily answered that question, but I'll move on swiftly. So what can you tell us about the new small claims court, which was recently operationalized by the judiciary?
Okay, thank you for that. So I know it's the court came into effect recently, and I believe the purpose of the court is to try and deal with the case backlog which has happened in the judiciary, because so many cases are being filed in the magistrates courts that is creating a backlog of cases. So the whole process is to ensure that the subject matter of a dispute between two parties does not actually go to the magistrates court, but goes to a small claims court, which is able to deal with a procedure or the disputes in an expeditious manner. So I believe it's a much needed process in the fight against case backlog.
Okay. Can you just tell me what the pecuniary jurisdiction of that court is?
I don't know. I stand guided.
Okay, cool. Sawa. So the last question. You said you're very conversant with conveyancing. What was the last lesson you had in your conveyancing class?
It was on charges.
On charges?
Yeah.
Okay, so have you looked at the procedure of registration and discharge of charge?
Yes, we have a formal charge and for an informal charge. And for a customer.
Okay, can you take me through the steps of discharge of charge?
Okay. So for the process of a discharge of a charge, once the charger has satisfactorily performed all the obligations that he's supposed to do for under the loan or the security, then the next step is for the chargee to actually the contract becomes terminated to the extent that the chargee no longer has a security or an interest in that specific piece of land, and now the property is now going to revert back to the charger after all the obligations of the charge conditions have been satisfied.
Okay, that's a good definition, but can you take me through the procedure? Maybe you've been taught.
Okay, we haven't yet covered the procedure yet. We're still in the into with Kigwatha. Yeah.
Okay, sawa. So then okay, let's make this a bit simpler. Tell me the procedure of discharge of a normal contract. Ways in which you can discharge a normal contract.
Okay, a normal contract to do with what exactly?
Any contract, whether it's a contract of sale of a property, of a car, movable or immovable, any kind of, how can you discharge yourself from a contract?
Okay, thank you for that question. So, there are a number of ways in which you can discharge yourself from a contract. Okay, the way I've understood the question is that in terms of you removing your liability from performing the specific obligations of the contract. So the first step would be obviously once you perform your obligations in the contract, then obviously your obligations are discharged from it. Number two would be through, say, for example, a force majeure event or an act of God happens, such as the COVID-19 pandemic. Such would discharge parties from performing the obligations on the contract 3 would be also through frustration. For example, if it's an unexpected event like through fire or burning of specific material which is needed for the contract to be performed, it will also discharge the rights of the parties from performing the obligations. Also, number 4, to some extent, I would say misrepresentation, where one party, for example, is given false information or misleading information about a contract. It makes the contract voidable to the extent that they do not actually have to perform those obligations because of being misled. So I believe those are some of the examples that I'll give.
Okay, thank you for that. Yeah, I think that's the end of the session. Solanka, will Alex go next, or should I just give my feedback and then I'll ask someone else?
Yeah. Maybe Alex can, because there's nobody
Can
else.
ask more questions?
Yeah, Alex can
Okay.
ask more, and then we can now wrap it up.
Okay, perfect.
Hey, good evening.
Good evening.
Yes, so I'll just ask you a few questions on probate, and then we can discuss later after Sumaya gives a feedback. So my questions I think are really simple. The first question is, what was the ratio in Reluenji case?
Okay, thank you for that question. So the main issue in the Riruenji case was to do with the African Christian Marriage and Divorce Act of 1937. So in that specific case, the deceased had married a woman under the African Christian Marriage and Divorce Act, and he also went and conducted a traditional customary marriage. So the main issue was whether the second wife was a wife for the purposes of succession. And the court held in that matter that she is not a wife for the purposes of for succession, because Section 37 of the African Christian Marriage and Divorce Act stated that it's not possible for the deceased to contract another marriage if he has contracted a marriage under the African Christian Marriage and Divorce Act. Yeah.
Okay, thanks. So my second question is a problem question. Let's say, let me just frame a question like 16-year-old Kijana Otieno bought a land in Kisumu and soon thereafter made a will in favor of his mother. Unfortunately, he died just 2 months after turning 18 years old. The mother and father of Kijana Otieno have had a contestation as to who is the rightful owner of the land. Advice.
Okay, sorry, my call was dropping. Do you mind just repeating the question?
Okay, let me repeat the question. So, 16-year-old Kijana Otieno bought land in Kisumu when he was, let's say, 16 years old. Unfortunately, soon thereafter, after buying that land, he made a will making his mother the sole beneficiary. So, about 2 months after he turned 18 years old, he died. So the mother and father are both claiming to be the rightful owners of this land. Advice.
Okay, thank you for that very interesting question. The first thing that I noticed is that this is a child who bought land at the age of 16, and we know that in the law it's not possible for a minor to conduct a contract or has a capacity to enter a contract if he's below the age of 18. Number 2, we know that for the purposes of succession, he would be defined as a child under section 3 of the Act. So a child does not have the capacity to enter a will. So to that extent, that will for that specific land which he bought would be invalid, it would be void. So even to the extent that the mother and the father are disputing on who owns that specific property which he bought, it would not be considered in court because the child did not have the specific capacity even to buy the land, and two, did not have the specific capacity to form a will. So it's void.
Okay, thanks. Thanks for that question. Thanks for that response. Sorry. So my last question is still on the law of succession. So can you give me just three consideration that one considers before determining whether a will is valid or not? Three considerations. The key considerations for determining whether a will is valid or not.
Yeah. Okay. Thank you for that question. So the first condition will be the testamentary capacity, and this is under Section 5 of the Law of Succession Act, which provides that in the making of a will, the person has to have the necessary testamentary capacity, and the locus classicus for this case would be the case of Banks versus Goodfellow, because in that case it held that for the purposes of making a will, the testator has to know that he's making a will, the knowledge of the will, and the contents of what he's doing and how he's distributing the property. So that'll be number one. Number two is whether the will was written and was attested to by two valid witnesses. And this is provided for under Section 11 A and B of the Law of Succession Act. So to that extent, two witnesses who are over the age of 18 should be able to testify that they agree or that they know that the testator is disposing of his property. Those are two. So number three is that this will has to be made out of free will. I can't remember the specific case for this. I think it's Cheese versus Lovejoy, or okay, stand guided on that. But the testator has to make this will out of his own volition and out of his own will. So with regards to Section 7 of the Law of Succession Act, it states that a will is void where it was made under coercion, or where it was made under fraud, or where it was made under importunity. So to that extent, those are the three conditions that would have to be fulfilled.
Okay, thanks so much.
Okay, thank you.
Okay, so I think we can dive into feedback. Alex, would you like to go first? My senior.
Okay, let me just give my feedback and then Sumaya will give her feedback. So I asked you 3 questions on probate. I think you really tried answering those questions well. The first question was you answered it very well. That the issue in revenge was whether a person was conducting a statutory marriage can conduct another marriage, and you got the ratio. It's a famous case. I think one of the cases in the law of probate which everyone must know. If you meet with a person like Anastasia or Ruto, they will almost definitely ask you a question around that area, and they have different positions as to which is the law. Is the revenge a proper law, or is it not a proper law pursuant to the Marriage Act 2014? So I hope you guys have, during our time at KSL, we really debated as to which is the right position. And I hope you have also had those discussions, and I hope you also know the positions of the lecturers with regard to that issue, because if you appear before someone like Anastasia and you and she asks you because she likes asking that question. She likes asking those questions which she knows people with a different view because they attend those classes. So if you appear before her and she asks you that question and you answer in a way which she does not agree with, she must fail you. That's how she goes about her thing. So you just be careful. Just know those Trilogy, Riogola, and what was the position then, what is the position now, not based on how you understand them, but based on the preferences of the lecturers. So that was it. That's the reason I asked that question. The second question I asked was with regard to a 16-year-old boy who buys a piece of land and then they make a will before they turn 18, and then they die after they turn 18. Of course, I think you tried to answer this question properly, because to the extent that you noted that a person is below the age of 18 cannot make a will. That question is basically on validity of wills. Section 5 of the law of succession. That's the starting point. Capacity to make a will. A person, that section, I think it says that for a person to make a will, they must be adults. Actually, it says that they must be a person who has attained the age of majority and who is mentally capable of making a will. So for you to make a will, you must not be a minor, and you must have a sound mind, so you can make a will. If you make a will if you are a minor, then that will be invalid. But then the point of ownership of land by minors, a minor can own land. When you look at, I think it's the Land Registration Act, Section 47 or thereabout. It contemplates a situation where a minor can own land. It actually says that a minor can own land, although not in their own name, but in the name of another person. It's section 47 years. It says that the name of a person under the age of 18 years may be entered in the register to enable the minor's interest to be held in trust, and shall be registered under the name of the guardian, either on first registration or as a transfer or on transmission. So a minor can own land. It's not true that a minor cannot own land, but a minor cannot make a will. So it's important to note that you can also look at section 47 of the Land Registration Act. And my last question to you, related to the issue of considerations before making a will. What are the considerations that a person takes, or what does a person look at before making a will? If you are to be asked a question on wills, it revolves around that area. Consider what validity of a will. Just like it's like the first question that I asked you. And this question not only comes during orals, but they must come as question on in the by exam. So you have to know the considerations, and you have to analyze all those considerations before you make an attempt at answering such a question. So there are 4 broad considerations that must be made before you determine whether a will is valid or not. 4. The first one is usually capacity, which you have just talked about. Capacity, section 5. You must be mentally sane. You must be a person of full age. You must not be a minor. That is the first. The second consideration is the form. A will can either be oral or written. The third consideration is knowledge and approval. Now, this is where there are so many things. That the person who made the will must have had knowledge and approval of the will that they were making. So knowledge and approval is divided into several subsets of, or it has several elements under it. Number one, there is the issue of time of knowledge and approval. There's a case of Parker versus Felgate. I think you guys have heard about that case, Parker versus Felgate. The general rule about time of knowledge and approval is that the time at which the testator must know and approve the contents of the will is the time when the testator executed the will. So the executor cannot execute a will to which he does not know the contents and then know the contents later after execution. So time of knowledge and approval is at the time of execution of the will. Of course, there is an exception to that, and the exception is where the testator had made a will and then probably they became mad, and then they later just they instructed somebody to make a will. So when they were instructing them, they knew what they were doing, but before the person, maybe their lawyer went and wrote down that will and brought it back to them for signing, they had lost that capacity the mental capacity, so they just signed. So at that point, they did not have knowledge and approval at the time of signing, but they had knowledge and approval before maybe they became mad. I hope you get the point. The second is the burden of proof. So the burden of proof usually is a person alleging that the will is invalid. The third is mistake. So if the mistake is a serious mistake by the testator, the will be invalid. If the mistake is not a serious mistake and a mistake which can easily be rectified, the will not be invalid. The fourth is coercion or undue influence. So if it is proved that this will was made by coercion or undue influence, the will be invalid. And then there is suspicious circumstances. You all know the case of Modi and Modi. If it is clear that there are suspicious circumstances with regard to which that will was made, the will be invalid. Number 6, there is the issue of fraud. If it is shown that there was some fraudulent deals before the will was signed by the testator, then the will be invalid. Finally, there is the issue of forgery. If there is forgery, it means that the testator did not have knowledge. So all those things that I've said fall under the knowledge and approval consideration. The last consideration is whether the will was revoked or not. So if the will was revoked, it's invalid. It cannot stand. If the will was never revoked, it means that the will is valid if all the other elements have been fulfilled. So there are 4 broad considerations. And even when you go to your exam, which must have this as question 1, you have to know those 4 things, and you have to know the cases which, because this is like 15 marks. Of course, they can bring so many questions on a question 1, but they all revolve around the issue of the validity of wills. Considerations. Number 1, just for emphasis, capacity of the testator to make the will. Number 2, form of the will, oral or written. Number 3, knowledge and approval, issues of fraud, mistake, undue influence and stuff. And finally, whether the will was revoked or not. So that's all from me. I think you did well. You tried even on that question, but I hope I hope I have helped you a bit on this unit. Thanks.
Yeah, thanks, Alex. You really have.
Okay, awesome. So hi Ndegwa. So first of all, I'm really impressed at how you're able to handle the weird questions that I was asking you. I think that ability to be agile and still continue with what the panel is asking you despite the fact that you don't know some things is very impressive. First of all, I'd like to commend your tone. I think your tone and your speed is perfect, like so far presentation wise. I hope you're also practicing the verbal and non-verbal cues, right? Are you doing some practice on that?
Yes, I am.
Yes, just to make sure. Yeah, just make sure your posture is okay, Nini. But so far, in terms of your tone and your voice, I think that's perfect. I think you don't need to work more on that. Okay, so there are a couple of questions. I don't even remember the questions I asked you, but you see the first question I asked you on why are you doing this oral exams today? You see, when you get okay, let me phrase this way. Every single question you get asked, you need to ask yourself, what is the panelist looking for? You know, like, why are they asking me this question? And so it's not, I don't think it was enough for you to say that, I'm here to do it as a requirement for my ATP and be admitted to the bar. I was waiting for you to, link that to professional ethics. There's a whole topic on requirement of becoming an advocate and admission to the bar, right? So Section 13 of the Advocates Act talks about the criteria. And one of them includes passing, any case CLE exam. And then Section 9 talks about what makes you an advocate, having a practicing valid PC, being part of the bar, etc. Right? So what I was looking for was you now to link whatever you're doing now today as to what it means to qualify as an advocate. So maybe you can just look at that. Then number 2, and this was a very hard question, but whenever you're asked, and this is for everyone who's listening today, if you go there next week, if you're next week or the other week or whichever panel you're in, if you're asked, what questions do you want to be asked? Please, 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 if if this is the only thing you'll take away from this meeting today, take away the fact that you have to tell them the specific unit and topic. That's it, straight without question. Don't tell that, okay, you might be good at commercial law, you might be really good at conveyancing, but never ever tell the panel, ask me if I'm okay with conveyancing, I'm okay with commercial. No. Tell them I'm okay with civil litigation injunctions. That's where you're narrowing the thing they can ask you. Because if you tell me today you're good at civil litigation and start asking you about grounds of the appeal that were there in the BBI case, or in a specific, I ask you, for example, tell me the grounds of appeal that were there in Morara's Supreme Court petition, and you have no idea about what the hell that is, you see. So this is a lesson that goes to everyone. Whenever you're asked, what do you want to be asked? Don't give the panel the unit alone, give them the unit and the topic. You see, if you tell someone, ask me probate intestacy, you've limited them to a lot of things. They won't ask you questions on intestacy. You'll only be asked on anything that, cuts across section 32 to 40 of the Law Succession Act, right? So I think that's a very important thing. I wanted to bring that fact out. Make sure you tell them the exact topic and the exact unit. So I don't stop at the exact unit. It's not enough because there's so many things. You guys are just in second term. There's so many things you still haven't learned in third term work. And if you tell someone to ask you anything, then you open a whole Pandora's box, yeah, of questioning. So that's what I wanted to, that's what I was leading with that question. And then whenever you're given, so I've noticed that I think you haven't covered a lot of procedure generally, but whenever you're given a question on procedure, whether it's especially in conveyancing or in any procedure related unit, I think I mentioned this before, please make sure you label or number your steps, right? So you say step 1, EVO, step 2, EVO. Why is that important? That's important because it helps you, it helps you mentally, number 1, keep the attention of the panel, but also in your mind, think on your feet as you count the points and make sure you don't miss a point. So try to do that. And then the question I asked you for mergers, you see, it just you first of all you mentioned a specific section, I think it was section 50 something, which wasn't correct. So if you're ever in a situation where you're not sure of the section, I think you can try to avoid it. But if you also don't know it and you continue to go with it, because trust me, these lecturers don't know all the sections, right? We don't know. I think it's just lucky that I remember that section 42. But if you're ever asked, are you sure of a question? That's the point that you tell them, I might not be sure of this and this and this. So I liked how you saved yourself. that was a really good save. So I think keep that up. Also in future, someone can ask you, when you say a statement, they can ask, are you sure about that? Find a nice way of handling that, especially how you react with your facial expressions. You see, with some panels, you'll be told to remove your mask. With others, you won't be able to remove your masks, right? So how you react to a situation where someone is confronting you or even continuously questioning you on one thing, because some lecturers do that, they continuously harass you or question you on a specific topic. So in those scenarios, make sure that you are able to maintain your calm, you're able to maintain your facial expressions, and you're able to how do I put it? But yeah, you get my point, right? You're able to continue with the form of questioning without sounding either impatient or disrespectful. This is a personal experience that a friend of mine experienced in the same panel during my orals, and it really cost her some marks. So make sure you continue that. When you're not sure about it, just let them know you're not sure about if they ask you, that is. But if they don't ask you, continue with that and be very confident with whatever wrong section you have. So, and then for the question, I think for mergers, the main thing I was looking for, I think you also haven't covered this, have you? I'm not sure if you guys have covered it yet.
Yes, we have.
You have? Okay. Yes. So for the main question for the mergers, so for mergers, it's sorry about that. Yeah. So for the mergers, there are specific, steps that you need to go through. So there are really nice notes from Mr. Wakimani. I'm not sure if you guys have them, but if you don't, please look for them. But mainly it will be classified as to pre-contract formalities, which includes, parties deciding on what kind of document they're going to use. Is it going to be a term? Is it going to be a, it's called what, term sheets? There are a couple of names they call that, what initial document. So
Term
a letter of
sheets,
offer, a term sheet, exactly. Yes, the parties will decide on that, and then on that aspect they'll also decide on inclusivity or exclusivity, as in, are parties going to be completely exclusive when they're discussing on mergers, and if they're going to have also non-disclosure agreements. And then you also have to look at, after that, now you go to the due diligence step, where all the parties will go into due diligence. They'll check into employment records, into contracts, etc. And the third part is usually disclosure. So post due diligence comes disclosure, and then finally parties deciding on the actual signing of the merger acquisition documents. Those are usually divided into two. It's either a share purchase agreement, SPA, or an asset purchase agreement, also known as it's called business asset transfer agreement, BATA, or a asset purchase agreement, APM. So, or sometimes depending on the transaction, it can have a mixture of two. It can be either share purchase or asset purchase, or can be a contract with both asset purchase and share purchase. Those are mainly, the skeleton steps. So you can divide it into that. Talk about pre-contract formalities, talk about due diligence, disclosure, and then the final signing of the documents. But those Wakimani notes are really nice, so have a look at them. Again, also goes back to how you can answer questions of procedure. Try as much as you can to give them step by step while explaining in each step and giving examples. And then I think last but not least, the question that when I asked you where did you reach in your last conveyancing lesson? Okay, so there's two ways you can handle this question. One is by actually saying the truth and telling the panel exactly where you reached in class, assuming hopefully by that time you'll be really good at that, the last topic. You'll have read throughout everything. It's a very common question. In fact, it was asked in the first week of our orals. I remember someone was asked. But anyway, so if you happen to appear before someone who's not your lecturer and they haven't taught you in that unit, and you know very well I'm not very good at charges, but the previous topic was leases, right? The previous topic that you'd learned was leases, and you're very good at leases because you read everything about leases and you know all the cases that have to do with leases. I'm not saying lie, but feel free to twist the truth and mention a topic that you're good at. But then you need to be very careful on how you answer, you go about it, because if that person is your lecturer, then you cannot, they know where they've reached. If you appear before class C lecturer, you can't tell them, you haven't taught us this unit, right? But if you appear before a lecturer who doesn't teach you, then take the opportunity to shine if you ask such a question. Of course, don't mention term one work because everyone will know you're lying. Don't tell them, oh, we are still on searches. Don't tell them things like that, or don't tell them unrealistic things like, oh, we finished the syllabus. Those things will not work. But something in the middle, close to where you are, or close to a topic you're very comfortable with, feel free to go with that. Yeah, so I think that's what I had to say. So I think for my line of questioning, I just want to let you guys know that number one, when you're asked questions that don't seem to relate to the law, always find a way to relate them back to the law as much as you can. Number two, when you're asked what question you want to be asked, please make sure you mention an exact topic with an exact unit. So I don't just don't say civil litigation or criminal litigation. No, mention the exact topic. You can say criminal litigation appeals, etc. Yeah, and if you're asked where you reached last in class, first of all, you have to assess and make sure those people are not your lecturers. And maybe, you can feel free to twist the truth a bit. I don't say lie, because I know this will go on YouTube. But yeah, so that was what I wanted to let you guys know for today.
Thank you so much, Sue. Yes, subscribe and like. Subscribe and like.
Welcome to the channel.
And welcome to my channel, yes. Anyways, thank you very much. Thank you very much. Now I'm seeing a hand is up. And Dego, you have something you wanted to say?
Yeah, thank you, Maya and Alex, for your great feedback. I'll really take it into account. I really appreciate it. So just out of 20, how do you say I performed? Just like a rough estimate.
That's a tricky one. Well, okay, I think if I was on your panel, I'd give you a 16. Just because I feel like your presentation skills were really good. It didn't matter the fact that you're not very conversant with most of the content. So I think for me, I'd give you that if I was on your panel.
For me, I would give you also a 16. I think Sumaya said 16. 16 or 15? For me, it's 16.
16, yeah. The same, yeah.
Yeah. 16 would be fair for me, but I always tell you guys, I mean, orals is about how someone decides how they just see you. I mean, don't beat yourself over your oral, just to do your best. But I think for me, that a 16 would do with your performance. Thanks.
Same for me, you'd get a 17, honestly speaking. Now, since it's getting late and we need to come to an end, I'm seeing Esther's hand is up and Gitau's hand is up. So since it's the last day, Mwandwa and I give our opening advice. I would advise in maybe 5 minutes each, Lavins, Alex, and Sumaya, to at least give you something. I know they have, but in 5 minutes to maybe encourage and motivate you and tell you just anything of the sorts. And Alex, because Alex, there's a way Alex is advice on all of it'll actually just show you how it's beyond your hands, how it's beyond you, and so forth. But before that, I'm seeing Esther's hand is up and Gitau's hand is up. So maybe we can sum it up by having Esther in brief, raising if it's a question and so, and then Gitau, and then now we close up. Alex, Lavins, and Sumaya. Well.
Hi, Salonka.
Hi, how are you?
Okay, thank you. So I just had one question to Alex. He'd mentioned about the Riruenji Riogola cases, and particularly section 3.5 of the LAC. So we were going through, or we were discussing this particular provision with a friend of mine, and we noticed that, okay, the Act tends to protect women or wives who have, okay, notwithstanding the provisions of any other law, a woman married under a system of law which permits polygamy is where the husband has contracted a previous or subsequent marriage, is considered a wife for the purposes of succession, that is for the purposes of the LSA. So when we are looking at it, and you've mentioned that, you know, Anastasia and Ruth really like asking these questions, we notice that the LSA only protects the woman who has been married under polygamous marriages. Basically, it only considers them as wives. So what happens in the instance where it is the woman who has been married under the monogamous marriages, the civil marriage, the Christian marriages, the ones who have not had their marriages registered under the Marriage Act. So you see, the Marriage Act literally states that any other, if you contract contract a marriage under the civil or the monogamous way after the polygamous one, then the monogamous marriage is not valid. It is considered, you're not considered a wife. So the LSA again does not protect that woman. So what happens in the instance where it's the polygamous marriage that has been registered or has been recognized, but the monogamous one is the one that's not recognized? How do we then approach, because we saw like that was a gray area, how do we then make sure that both of them are equally protected under the LSA for succession? Yeah. And
Esther, just a quick question. Are you in Anastasia's class? Which class are you
no,
in?
no. I'm in Odera's. I'm in class G.
Oh, okay. So
Yeah.
makes sense. Continue.
Yeah.
Okay, I hope I got your question, because you are asking what happens when a monogamous marriage is conducted after customary marriage, essentially. But then you cannot
Yes.
conduct a mass marriage after customary marriage. You see,
Yeah.
it's not possible, because a monogamous marriage, a customary marriage is a marriage where you can marry more than once. You can marry, like, a person can marry two wives. That's a customary marriage, or this other is essentially customary marriage. But then once you have conducted a customary marriage, it means you can marry another person and a customary marriage. But now, can you marry a person and a monogamous marriage? It's not possible, because you already have the man already has a wife. So they cannot marry under a system of law which does not allow more than one wife. I don't know if you get my point.
Okay, that I get. But you see, the Act literally states that so long as you have been married as under the polygamous way, whether your husband has contracted a previous or subsequent monogamous marriage to another woman, you as the first wife, basically, you as the woman who is married under the polygamous way, again, it's not even you as the first wife, it's either you are the first wife or the second wife, you will be considered a wife. But you have to be specifically married under the polygamous way, which I don't understand why there is that disparity, because it literally now gives leeway for succession proceedings so long as you have been married the polygamous way, whether the monogamous marriage was contracted first or later on after the polygamous marriage, then you will still be considered a wife. I think that's the issue that Anastasia and Ruto tend to ask about, or I don't know. I'm really confused.
Maybe Esther, I can attempt answering that. So
Okay.
during Alex, do you want to go first?
You can go first, Sumaya.
Okay, sorry. So during okay, so I this was a very hard, it was always a debate in KSL. And so just to answer your first question directly, the reason why the Act specifically says notwithstanding but gives a provision for polygamous marriage to be involved is because if someone is part of or contracts a monogamous marriage today and continues to contract another monogamous marriage tomorrow, then they'll be liable for bigamy. You're aware of that, right?
Yes.
Yes. And that's why the Act specifically gives the fact that that marriage has to be in a polygamous aspect. So it doesn't matter whether the previous marriage was a monogamous or polygamy, but one of the marriages have to be polygamous. And the reason behind that is because if you contract two subsequent monogamous marriages, then you'll be liable for bigamy. For example, today, person X goes and has a civil marriage, right? Civil marriages are monogamous in nature. Then they go the next, after a year or two, and goes and contracts a Hindu marriage. Yeah, that means this person will be arrested.
Okay, thank you.
Yeah, but let me just Alex can go, then I think I can give another clarification. But generally, what I wanted to say, which I think is the most important thing, is that when you're talking about succession, you need to forget about marriage. For me, and that's something very important, our undergrad lecturer told us. She told us, whenever you're discussing succession, forget about marriages, right? So, and that section 30, section 3.5 starts with the caveat. It says, notwithstanding, right? Any other existing law. So basically, what this law is telling us is that despite whatever kind of marriage law that exists in a country, once someone is dead, now we go to the realm of the LSA. So I hope that makes sense, and I hope it doesn't confuse you anymore. So it doesn't matter whether the previous marriage is polygamous or monogamous, or the subsequent one is polygamous or monogamous. All of them will be regarded as wives. It doesn't matter whether the marriage is recognized in law or not. And now this is where there's usually a conflict between what Anastasia and Roto think about. So one lecturer believes or is sure that there's no longer presumption of marriage, while the other one doesn't. So just find out exactly. I don't know if their stands change every year, but find out what they both think. And if you appear before them, make sure you of course agree with whatever they're saying or bring up that argument.
Okay, thank you.
Maybe if I can just chime in a bit before Alex takes it over. The issue of the monogamous wife is the normal wife under the definition of a wife under Section 2 of the LSA. And the monogamous wife is the wife under the Christian marriage, who is also covered under Section 26 as a dependent in the normal way. Read together with Section 29, the definition of a dependent. 3.5 was actually meant to cure wives, like our rural mothers who are married under the traditional ways. Then the husband came later on and married a wife under the Christian marriages, so much so that the Christian marriage is the only one which will be recognized, but our traditional mother and the rural areas will not be recognized in the event the husband dies, because everything will be taken by the wife who was married in church. So the rural mother will have actually lost entitlement into the estate of her husband. That's why 3.5 came in to cure that remedy. And when you look at the normal wife who is a monogamous wife has been protected under Section 26. If it was a case of now, since there's a woman under 3.5, then it will fall under a monogamous a polygamous type of a union, which can end up distributing the estate under, I think it's Section 40 of the LSA, because it's a polygamous marriage. But in large, 3.5 is only meant for the traditional wife. But if this husband later on marries a wife in church, that wife is usually well protected under Section 26. And if 3.5 manages to win entitlement under the curfew of 3.5, then that marriage, or rather that estate, will be distributed under, I think it's usually Section 40, which talks about distribution of the estate in the event of polygamous. If you're in Odero's class, I think you'll have gave you a decision in the Court of Appeal. It's usually, I think, EKM or EMK, and I cannot really put up the initials, but I know it's usually related to the Koinanges, who is a cousin of Jeff Koinange. It's a very interesting case which juxtaposes the argument under 3.5, and the wife under the Christian union. I think if you're in Odero's class, you'll have come across that decision. It's a very interesting case because it gives the arguments in favor and against the issue of the wife under 3.5, because there were so many wives in that Koinange estates who are were contesting the portion of the estate in that guy's property, and the court actually referred back to the estate of in the case of Elizabeth Ndolo, which is usually the locus classicus on that argument of 3.5, and juxtaposed it with the current scenario and said the 3.5 wife is protected because she was the traditional wife. I think if you can remind me tomorrow, I can send that authority, because for now I think I'm having a mind block. So maybe you can remind me tomorrow. But in short, what I can tell you is the wife under 3.5 has no interference with the monogamous wife who is married under the church or Christian marriages, because that is the wife under section 26 within the definition of a dependent, as read with section 29 and section 2 of who is a wife within the LSA. And like the previous speaker, Sumaya, said, there's a thin line between marriages and succession. In the realm of a marriage, the 3.5 wife is not recognized anywhere. But for purposes of succession, she's well anchored under 3.5 to succeed in the estate of the deceased person. I think Alex can take it over.
Okay. Thanks, Moses and Sumaya, for that. I think what I can do, I can just give a brief overview of this issue of section 3.5, and then a brief history and the positions of the lecturers when you were at KSL. I think, I don't know, different people interpret this issue differently, and as Sumaya said, we had a lot of arguments when we were in KSL, especially class B. There used to be arguments every day about the issue of section 3.5. So what happened is that
cohabitation.
So what happened is the Marriage Act Cap 150 had a section which was section 37. Section 37 said that a person who is married and a monogamous type of marriage cannot contract any other type of marriage. So, assuming that a man was married and a monogamous marriage or a Christian marriage, it meant that they could only have one wife. But then, as you know, during those days, 1970s, people used to have more than one wife. So a guy would go and marry under monogamous marriage, and then they marry another person under customary marriage. So this guy would have two wives. So when he died, both of the wives would want to inherit his property. So when they went to court, that's where revenge and Reogola came from. The women who are married after the monogamous marriage were told, or after the monogamous marriage were told they could not be considered as wives for purposes of succession. So Parliament introduced this new section, section 3.5, which said that notwithstanding section 37, that section which said that a monogamous man cannot marry a man married and a monogamous marriage cannot marry another wife, we will allow such women to inherit, notwithstanding the fact that they are not considered as wives. So these women will be wives for purposes of succession. So section 3.5 changed the position in Kinari Ogola. So that remained to be the position. Actually, when there's a case, Irene Jerry Mashari, I think it's a 1996 case. If you look at that case, they give that history. So after that amendment of section 3.5 that amendment introduced in section 3.5, that remained the position until 2014. The 2014 Acts now laid down the position that a monogamous woman is this woman, a woman married under civil marriage and a woman married under Christian marriage. There were some regulations, I don't know legal notice number what, which came into force in 2017, and pursuant to that legal notice is what Ruto likes saying, that we went back to the position before Riogola and the position in Riogola and Rilwenji. So that this Marriage Act 2014 made Section 3.5 redundant. That's the argument. Actually, there's a CLE question, a July exam, which asked that question. As the Marriage Act 2014 rendered Section 3.5 of the Law of Succession Act redundant? And that's why now the positions differ, because according to Anastasia, she says that the law which governs the law succession issues is the law of succession and no other issue, no other law, just as Sumaya said. So that is Anastasia's position. So according to Anastasia, even a cohabitee is a wife, pursuant to Section 3.5. Even if whatever, whether monogamous or whatever you're talking about, those people are wives because Section 3.5 is the law. But now when you come to Ruto, she used to say that no. The Marriage Act 2014 and that subsequent legal notice in 2017 changed the position such that if you are not, if you are married and a monogamous, you cannot marry another wife, blah, blah, blah. So you cannot be considered as a wife for purposes of succession. So that's the entire, briefly, that's the entire thing about this. So for me, I don't want to say that I'm on this side or the other side. Just know the position which the lecturers take on this issue. I don't know the Odera's position. I don't know if Ruto's position changed between last year when we are doing our ROS to this year, or Anastasia's position changed. But just know their position. I always tell you guys, KSL is a strategy. Usiende hapo uende hapo kusema ati wewe vitu zako ati you know the law. Just tell those lecturers what they want to hear and get over with it. Thanks.
Thank you.
Okay. I think that Alex, maybe you could close it up. Anybody else who has some piece of advice?
Okay. So, let me talk and then maybe Somaya, Moses, or Lavin can say something. So I think you guys are starting Oros. I think next week, if I'm not wrong. I just want to issue all the best. I hope you guys will get good marks. God willing, hopefully above anything above a 10 is okay. If you get above 15, even better. But whatever you get, just know that always exam are always exam. A person can look at you and they like you, and you say a lot of nothing and you get 18 marks or 19. And a person may look at you and they are like, oh my God, what is this character doing here? And they fail you for nothing. So just get in there, do your best. If you believe, just pray to God for His grace during that day, that whoever you appear before will have favor upon you, and you will pass. And if you don't pass, you have 60 marks at the bar exam, and you will, of course, you will pass. I think you guys are serious. You know, it's this time of the night, and you can see that so many people are logged in. So I think you guys are serious. I think we are also serious during our time, and KSL with that mentality ya lazima tupate 9 piece, lazima tupate 9 piece. You'll get that 9 piece. No matter how these oros turn up. I don't, hata zikienda ambayo usilie. During our time, I used to see some people crying. Just know, I think I told you my story earlier on. I went for my oros, and in my second minute during the oros, I was like, hii kitu endi vizuri. Because the type of questions I was asked, they are really questions which until today I've never known the answers. But I had a 14. When the exams came out, the list, I had above 60 in all the exams. So hata wangenipea what is 14 minus 10, hata wangenipea ine bado ningepata 9 Ps. So usitisho, otherwise all the best.
Alex, umesema what was the tissue? So I think, I don't know why I just imagined a trolley, but but I think what Alex is saying is true. Hata sisi when we were doing our when we were studying for exams, I remember we used to have sometimes late night discussions and nini. I'm saying it's almost midnight. The fact that you guys are logged in here and you're listening and you're willing to learn, that goes a long way. I think for me, my last piece of advice would be the same thing I said day one. Day one when we started this session, I said orals ni vibes. And I'm just going to repeat that. Orals ni vibes. Vibes tupu. So don't be so hard on yourself. I know it's really easier said than done. When in KSL, I remember even me, we would have, my friends would finish KSL before and they're always like, you'll pass, everything will be okay. But you're like, how do I know? When you're now in KSL, things are hard. It's hard for you to imagine, the thought of failure is carrying, the thought of passing is also, it seems very far-fetched. But yeah, just as Alex said, most of us really, really passed. Like, guys were getting 80s and 70s and 60s. Like, most of us, the least we were getting was around that. So everything is going to be okay. I think strategy going forward, what I'd say is very important is you've been in 2 terms in KSL, and this I think goes beyond orals, because I think orals is just a 20-mark affair. You have 80 marks to work on. Minus your projects, you have 60 marks to work on. So from now, it's all about just being yourself, being true to yourself, especially when you start 3rd term. I think most of you guys by next week will be waiting for 3rd term now, right? Because most of you will have done your orals. But find what works for you and stick to that. If your group discussions work for you, go for it. If personal studies work for you, do it. If staying up at night works for you, do it. If tuition works for you, do it. If you're a morning person, do that. Find whatever works for you, close the noise, and focus on that. And then for oral strategy, during the orals, also again what works for you. But please take a lot, like rest. That's what I'll tell you guys, especially the night before your exam. Read as much as you can before, but the night before, rest. Be very present during your orals. Dress well. Try to drink water. Try to sleep enough. But at the end of the day, I noticed most of my friends who are currently in KSL, people aren't sleeping. Sometimes I text them at midnight, they're still awake. In the morning, they're still awake. So try to sleep as much as you can. Try to rest. Try to be fresh-minded, and try to apply everything you learn. Like whenever you're given a question, apply anything and everything you know. Answer that question from that perspective. I think that will help them more. Other than that, once orals start, there'll be a lot of anxiety all over the class groups. There'll be people sending their questions. Again, find what works for you. For me, I was those people who would always read the questions as they come in and analyze them and finish with them. But if you feel like it's bringing a lot of panic or tension for you, maybe log in at the end of the day. Like you can stay offline, log in at the end of the day, collect all the questions and go revise them. But most importantly, make sure you're revising the questions as they come, because you can be asked the same thing. Collect all the questions, have a strategy, get to know who asks which panel or which lecturer will ask this kind of questions, and prepare those questions so that during your day, if you hear that you're landing in a panel that has lecturer A and B, you remember lecturer A and B last or yesterday or 2 days ago asked this question, and so they might ask something around. Again, just as Alex said, KSL is strategy, and strategy is everything. So don't leave any I'd say what stone unturned. Try to do as much as you can, but also balance it out. Make sure you're sleeping well, you're drinking your water, you're eating properly, etc. Other than that, I think you'll all be okay. Most importantly, remember it's vibes. It's 20 marks. When you go there, be patient. Be confident. Confidence is a lot. By the way, enter that room, own it. Do what you can. At that moment, if you have an opportunity to save your marks, save them. If again your questions are not also very good, just persevere, finish the oral questions, and most importantly, when you leave that panel, forget about the oral exams. Forget about it at all. Like, yes, you can discuss with your friends and your study groups and everything, but forget about it, because whatever has happened, and now you focus on the future. And what does the future entail? Once you finish your oral, please, come over week 1, or week 2, week 3, whatever, take some time to rest. Most importantly, number 1, rest. Then number 2, sit down, strategize, and start working for third term. If you have your discussion groups, continue. But most importantly, now you should focus on content and drafting. Those are the 2 important things that will help you for the bar exam. Yeah, I think more or less that's it. There's something else I wanted to say, but it seems like I've forgotten it now. But yeah, also what I wanted to say is, between now and the day you're sitting for oral exams, do as many simulations as possible. I hope you guys have, personal groups, but do a simulation. Simulations will take you a long way. I think by the time I had done my oral exams, I had done simulations throughout a whole semester, if I'm not wrong. Like, with my discussion group, would constantly go through oral questions and ask each other and critique each other and give each other feedback. And you see, well before oral exams, I knew my weaknesses were A, B, C, D. What I need to work on was this, At a certain point, I knew the only thing I need to work on for my orals is a bit of content and my speed, and I just worked on that. So now most of you guys have volunteered in this group, that you've raised your hands. Whatever feedback you're given, go back to that feedback, work on it. Work on the things that are remaining. Whatever you have not covered, that you feel, if you're in week 1, there's something you've not covered, just do your best, try kidogo, but also don't assume, don't expect yourself to know everything. As we entered that room knowing quarter the syllabus, and we still, got good grades. So don't be so hard on yourself. Do whatever you can, and I think leave the rest to God. If you're religious, if you're not religious, yeah, the universe will do its thing. But yeah, so all the best, guys. Please remember, rest, orals ni vibes, malizeni hizo exams, and yeah, bora admission at the end of the day. And all of you, tutakuwa hapo Supreme Court celebrate as you wear those wigs. So yeah, focus on that.
Yeah, I think that's fair. Lavis, thank you so much. Thank you so much, Alex. So I think we'll close the meeting. Lavis, do you have anything to say? Are you in, Lavis?
Yeah, I have nothing to add. Whatever has been outpoured by all of you is quite substantive. Yeah, so the ball is now on the students' court. So either you let it roll or you keep hiding it. So yeah, with that said and done, I think once you've been subjected to orals, send those questions to the WhatsApp groups. For those who haven't perhaps done the orals, like those ones beginning on Monday, send the questions. We go through them on the WhatsApp groups for those who are still waiting to face the panel. So with that, I think I would close this meeting. So it stands adjourned until next time, inshallah. So yeah, you have a good night, you all.